Good morning, everyone. The State and Local Government Committee. Happy New Year to all, and it's great to see you guys. We have a number of public work sessions today. Good morning, Kristen. And I would like to start with introductions, if we could, on this side of the table.
Good morning, all. I'm Wayne Farron from Jefferson. I also represent Wiscasset, Alna, and Whitefield in District 47.
Good morning. I'm Representative Dave Rollins from District 59, right here in Augusta, right here on the west side. It's good to be back.
Welcome. My name is Lynn Copeland, and I'm proud to represent the folks in Saco House District 130.
Good morning. My name is Senator Penny Beebe Center, and I represent all of Knox County except for Idaho and the town of Washington.
Good morning. My name is Sue Salisbury, and I represent House District 128, which is part of Westbrook. And I do also want to welcome our new committee clerk, Liv. Welcome, Liv. I'm glad that you're here. Welcome back, everybody.
Hi, good morning, everybody. My name is Lori Gramlich, and I represent House District 131, which is the lovely seaside community of Old Orchard Beach, and I'm also the House Assistant Majority Leader.
Thank you, Mr. Chair. Good morning, all. My name is Randall Greenwood. I proudly represent my communities of Litchfield, Monmouth, and my hometown of Wales, spanning in both Androscoggin and Kennebec counties.
Good morning. I'm Kimberly Pomelo. I represent House 85, which is Standish, Maine.
Morning, everybody, and welcome back to Augusta. I'm Representative Adams. I represent the beautiful towns of Acton and Lebanon, Maine, District 144. Thank you.
Good morning. I'm Joseph Underwood. I'm from District 5, which is the central part of Aroostook County. Good morning and welcome.
Good morning. I'm Will Toole. I represent House District 10, which is central Washington County, and it's great to be with everyone today.
Thank you. And I'm Joseph Baldacci. I represent Senate District 9, which is the city of Bangor and the town of Herman. And I co-chair this committee with Representative Salisbury. At different moments, I may have to go to health coverage, insurance, and finance to see, because I'm also on that committee, so I may be going back and forth. But the first thing I'd ask is if we could have a moment of silence regarding the accident yesterday. It was very tragic. The two deceased DOT workers, the injured worker, and all the families involved. If we could have a moment of silence for those individuals. Okay, thank you very much. I think that, Kristen, we have a number of public hearings, but I was going to recognize Representative Salisbury. I think we're going to table 1741. We might as well do that up front, if that's okay. I think that's still being worked on. Is that right, Representative Salisbury?
Yes, I've heard from the people working on the bill, the representative, and the law enforcement agencies that have been working on the bill. And so I would like to make a motion that we table this bill for 1 week.
Is there a second? It's been moved and seconded. Any discussion? Oh, yeah, thank you, Representative Greenwood. I apologize. All those in favor? Okay, appears to be unanimous of those present. So then the first item on the agenda would be LD 849.
Certainly, if I may, Mr. Chair, I just have an anticipated workload document, if I may just distribute first, just to help set kind of the committee's workload, just for a few moments, and then I would be pleased to jump into LD 49 after. So Liv is actually passing around just kind of a quick memo from me on Blue, which is like our bill analysis paper. That's just an anticipated workload document for this session. I won't go over it in great detail, but I'll just go over the headings, and certainly I'm here to answer questions if members have them or afterwards as well. Currently, the State and Local Government Committee has the following bills you'll see at the top in the possession of our committee presently. We have around 11 carryover bills, and some of which we'll be considering today for work session. We also have, you'll see I also included the 10 bills that were voted and reported out of SLG in 2025 and subsequently carried over this year, either on the AFA table or the study table. We will have pretty soon a review of the governor's proposed supplemental budget coming up in the coming weeks, and I will guide the committee through that process at that time. You will also see distributed concurrently, or perhaps coming around right now, is also a review of the regulatory agendas the committee has received. This is just pursuant to Title V, Section 8060, subsection 5. You can certainly review that at your leisure. This was distributed from the executive director on July 2nd, but there is a requirement in statute for this information to be distributed for your review at a public meeting. So that document can be reviewed at your leisure. Upcoming this session, we also will have, which takes place every second regular session, is quasi-independent state entity reviews. You can anticipate that taking place for both the Maine Government Facilities Authority and the Maine Municipal Bond Bank. Around March, reports will be received by February. And lastly, I do have highlighted for the committee reports expected during the second regular session with authority for legislation. I do have a separate list if it is of interest to any committee members around state and local anticipates receiving around 25 to 30 reports each year. And I've just highlighted the ones that have authority for legislation. So if you have any questions about those, or if committee members are looking for a presentation from any of the entities as those reports are received, please do not hesitate to contact me or the chair for further opportunities there. So thank you for letting me go over that briefly, and certainly am available to answer questions now or later at the direction of the chairs.
Okay, this is available to the public, right? Is this available under committee materials?
It's not posted online, but I do have some extra copies. And
Well, I think, it might be helpful to have this under committee materials.
Certainly.
No, I think that's very helpful. It's like a little guide for us. But it might be helpful to the public too, to kind of simplify, because sometimes people will ask, where certain bills are or what's happening with them.
Certainly, I could make a request for that to be posted
Okay.
on our committee materials webpage.
Thank you very much.
No problem.
So LD 8, are there any questions by members of the committee? Okay, LD 849.
Thank you,
Want to
Mr.
start
Chair.
with that one?
Absolutely. I have some additional materials to be distributed.
Right. Looks like a light reading situation.
Luckily, most committee members will remember these materials. I tried to re-photocopy what may have
I'll have
already
to
been
run
in
that
here.
through my artificial intelligence generative summary. Good luck. Are there amendments to this bill since we last spoke?
Yes, thank you, Mr. Chair. So what is coming around, you are correct, there is an amendment that actually is being distributed in the packet that Liv has coming around, as well as a colored copy that I believe is also provided by the sponsor that will also be circulating. But as a quick recap, if that may be helpful, where we left off, this is LD 849, an act to establish a recall process for public school board members. The committee did hold a public hearing on March 24th, and at that public hearing, the sponsor shared that they would provide a new draft amendment for the work session, working in partnership with the Maine School Boards Association. So the committee did receive on April 14th a new draft amendment. So there was that first amendment distributed. There is a new amendment today that I believe Liv is also passing around right now. You will see it in color copy. for the committee's consideration for today. So you'll see redistributed to aid the committee in its consideration today, the previously distributed bill analysis from April 14th and that first proposed amendment back in April of 2025. You will also see the new materials, which is what Liv is passing around with the color-coded new sponsors proposed amendment. And I also will note my records indicated that at the one work session that the committee held on this bill previously, there was a request for copies of the previous bills considered in the 131st, similar to this topic, as well as the amendments that came out of committee. There was some discussion from committee members at the work session for a request of those materials at the next work session, which would be today. I'm happy to review any of the bill analysis again if it may be helpful, or proceed as the committee directs.
Now, how does the committee wish to proceed? Any questions? Representative Copeland? I'm sorry.
Thank you, Mr. Chair. I think to recap. after-
Recap. Okay.
Yeah, the holidays and everything.
Yes, that makes sense.
I appreciate it. Thank you.
Sure.
Certainly. So I will be happy to go over this bill analysis and offer any updates to the committee.
Okay.
So this bill as printed, LD 849, provided that public school board members may be recalled only for specified behavior or misconduct and may not be recalled for the performance of a required duty or a discretionary duty. The petition to recall the school board member must be signed by at least 25% of the voters who voted in the last gubernatorial election in the municipality, or if the school board was elected as a school board member at large by at least 25% of the voters who voted in the school administrative unit in the last gubernatorial election. The recall must be approved by a majority of the voters in an election in which the total number of ballots and at least 35% of the number of votes cast in the municipality, or if applicable, the school administrative unit in the last gubernatorial election. I will note from that summary, the sponsor's new proposed amendment does change some of the language as it relates to the summary, of course, for the original bill as printed. LD 849 would enact new sections of law. I will note that current law governing the recall process of school board members is governed in Title 30A, Section 2505 in the first paragraph. I will note that statute is appended. Article 8, Part 2nd of the Constitution of Maine gives to municipalities the power to amend their charters on all matters not prohibited by the Constitution or general law, which are local and municipal in character, known as Home Rule Authority. And in Title 30A, Section 2505, it provides that except as otherwise provided by the municipality's ordinances or charter, an elected official of a municipality may be recalled from office pursuant to this section. And it defines official means any elected or appointed member of municipal or county government or of a quasi-municipal corporation. So you'll see the current statute governing the recall of officials is governed in that statute. And these, the printed bill as printed and proposed amendments for the committee's consideration outlines a specific newly enacted process for specific to school board members. Similar legislation was introduced in the 131st legislature. The State and Local Government Committee considered LD 1102, an act to authorize a recall election for a school board member. LD 1443, an act to establish a recall process for school board members, and 1181, an act to allow for the recall of an elected municipal official for any reason. And that third packet that was distributed that includes the text of those bills as printed, as well as any amendments that came out of the committee from the request at the last work session. Potential issues for consideration and proposed amendments. The committee did review a number of these concerns with the first amendment, and the sponsor may be able to speak to whether or not those concerns have been addressed in their second updated proposed amendments. There were some concerns around clarity regarding who would verify whether a school board member met the criteria for a recall that was established in the original bill as printed, raising concerns of possible lawsuits of those if those vested with an interest in the recall effort were tasked with verifying the criteria established. The committee discussed concerns around further clarity in the bill as printed with section 1005, subsection 1, paragraph B, which stated that a board member could be recalled if they'd failed to perform duties prescribed by law, with the School Boards Association raising the concern that the committee could perhaps reference duties of board members as outlined in specific provisions of law to more clearly define these criteria for board members and residents, to improve safeguards for board members to feel confident in decision-making without fear of recall if they're acting within the parameters of their duties. There was some concerns around creating a more thorough process to petition for a recall, suggesting to the committee that the petitioner cite specific examples of violations and back up the claims outlined in their petition. And there was a request for further clarity around who has grounds to file a petition against a school board member, posing questions for consideration such as whether any member of a municipality or school unit is allowed to petition, and raising concerns that in many districts, a school board member may only be elected by voters of one district in their municipality or by just one town, raising the question of whether any resident of an SAU may be allowed to recall a school board member or those from within the board member specific voting district. It is my understanding some of the new language in the second proposed amendment does address some of those concerns for the committee's consideration. There was also cited general concerns for the committee's consideration around language that may be broad or undefined that could allow situations where individuals use the recall process to push out officials because they do not align with their beliefs, or potentials of added costs, citing concerns of recall elections requiring a separate election that could lead to additional expenses. There were some technical considerations that were raised that I believe the committee also addressed in discussions last time around language. And that previously proposed amendment was distributed electronically on April 11th.
Okay. Questions? Yes, Representative Salisbury.
Is it possible to hear from Representative Sayer about this amendment?
Yeah, absolutely. Representative Sayer, you want to come forward?
Thanks for being here, Representative Sayer. I was just wondering if you could talk to us a little bit about the work over the interim with Maine School Boards Association, or whatever that work looked like to come up with this new amendment.
Absolutely.
Thank
Thank you, Representative Salisbury. Thank you, Senator Baldacci and members of the committee. I observe that I am subbing for Senator Martin, who's currently over in tax, which I abandoned to be with all of you. And yes, I'm happy to speak to your question. To recap, the goal of this bill is to establish a common standard for recall across the state with clear criteria, fair criteria, and a clear threshold, so that the process of recall can go forward and go forward in a way that is fair to the citizens and fair to the elected officials, and minimizes the interference with the proper execution of duties of school boards by properly elected school board officials. We all, regardless of our viewpoint, regardless of our politics, I think we all understand the challenges that face us as elected officials and the difficult decisions that we need to make, and being able to carry out our duties, knowing that we are held to fair criteria and held to the decisions of the electorate through regularly scheduled elections is our primary duty, and that recall is an exceptional exercise of democracy for exceptional circumstances. So what we have done with this amendment is to address some of the things that were, well, hopefully all of the things that were raised last time, including the voting body question, the question of which, when you have an MSAD or an RSU, who may bring a recall for an official. The objective there is simply to clarify that it is the body that elected that official that will, perhaps I should pause. Thank you. That the body that elected that official is the body that can recall that official.
Okay. Can I ask a question?
You bet.
In terms of these, let me just look at the memo for a second. The Maine School Board Associations had certain requests for consideration. Does your amendment address those?
It does. There was quite a bit of dialogue with MSBA in the interim.
Mhm.
And this amendment reflects their input. In many cases, some of the things that they raised as questions were resolved by reverting to an earlier form of drafting, which is this amendment.
Okay.
So I think it's fair to say, and we have representatives from MSBA here who can speak directly for them. But this language has been developed in complete coordination with MSBA.
Okay. Questions? Yes, Representative Tool?
Thank you, Mr. Chairman. So I'm a bit foggy on all of this, as probably most of us are. But my main question is, to what extent does this mirror exist, recall law for municipal officers? And along with that, would there need to be training for municipal officials that are going to have to navigate this new law? So I guess I'll leave it there.
I don't think I can speak accurately to everything the municipal official may or may not know in carrying this out. There is a general standard of recall of municipal officials in Title 30A, Section 2505. So that's currently spelled out in state law. What this does is create some cross-reference to that for school board officials, and also creates some distinctions between school board officials and other municipal officials. I believe that currently a municipal officials can be recalled only in very limited circumstances, including the commission of a crime that occurs during their term of service, the victim of which is the municipality. So this actually creates some broader grounds for recalling a school board official than the grounds that exist for recalling a municipal official.
Unless they're charter, right? Isn't a charter municipalities
A
allowed
municipality, yes.
different procedure? I mean, allowed to do their own procedure, correct?
A municipality, including mine,
Yeah.
may have a recall provision in its charter,
Right.
and it may or may not reference school board
Right,
officials.
right.
So if a charter has a provision, one would hope that an elected official elected to administer that charter would become aware of that. And MMA, the Maine Municipal Association, may provide training for those municipal officials, but I don't happen to.
Okay. Yes, Representative Greenwood.
Thank you, Mr. Chair. Thank you, Representative Sayre, for being here today. Following up on the charter communities. So if a municipality has a charter, this will not affect them in any way, shape, or form. Can we confirm that?
We can confirm that that is not the case, that this would create state law that would differ from charter, and the state law
Okay.
would govern in this case.
All right. Having worked heavily on a similar bill in the 131st, I think we work together on some and agree to disagree on others. But I'm very concerned about taking away what's called local control with this. That those that have a charter, that be the supreme operational status for their community. And, you know, I think the analogy was from Senator Nangle in the previous session was, if you want to recall somebody for driving a blue Ford truck, you can state that on your petition, circulate your petition, and if people want to remove a school board member because they drive a blue Ford truck, then that would be acceptable. Not that I think that's acceptable, but that process is there. So I'm very concerned that this is going well beyond and taking over of local control. Would there be any consideration for excluding municipalities who have gone through the extensive daunting process of getting a charter to exclude them from this type of language?
There was a lot of consideration given to that. And I think you and I are in agreement in some respects and in disagreement in others around this area, because I think permitting the blue Ford truck example is what exists in some communities currently, whether they have a charter or not. At least that's been the practice in some communities, whether they have a charter or not. And that is to the detriment, I think, of local control, because duly elected officials elected by a majority of voters in an election are now under threat of removal or under significant additional pressure in performing duties that have become jobs that are flashpoints for national political debate that is interfering with their proper conduct of having their primary focus being on the students in their community. So all this is defending is the local control of the electorate that elect their school board officials and then see them faced with recall actions that are frivolous or viewpoint motivated. And I say that not from one side or another. I have seen as recently as last week, and the threat of recall was voiced at a particularly ugly school board meeting in an MSAD that is not my own, where the untoward behavior was on full display from people across the political spectrum. And it is my concern that school boards are now not getting the candidates that they could get that would be excellent public servants because of this environment that we are in. And I see it as an offense of local control
Okay.
to defend the electoral.
Representative Sale, let me just ask you a question. How
Sure.
many communities, or Kristen, how many charter communities are there?
Thank you for that question. I don't have that information presently, but I could certainly try to get that.
Yeah, I mean, do you have a sense of how many there are, Representative Sale?
I have no sense. I'm sorry.
Okay, because it's usually larger communities, right? That are allowed to have their own charters. And I understand your viewpoints. I understand what we're trying to accomplish, what you're trying to accomplish and the reasons why. I'm just not totally sure that forcing this on charter communities, because that was the whole point of that. I think I understand your point, but I do share some concerns that I don't want to impose this on those communities that have charters and the local control. Having served on a city council for 12 years, I've seen plenty of arguments on all sides of the ideological spectrum, but I wouldn't want the state telling my community how they should handle that. That's all I'm saying. Okay. But I think that the overall goal of what you're achieving is good. I'm just not sure I'm ready to impose it on the charter communities. That's all I'm saying. Yep. Representative Gramlich.
Thank you, Mr. Chair. Thank you, Representative Sarah, and the committee and the chairs might indulge me for a moment as I'm playing a little bit of catch up here.
That's
I
all right.
understand this is a work session, not a public hearing.
Yeah.
However, I just wanted to follow up to my colleague to my left's questioning, and certainly the chair. Representative Sarah, as I'm reading the summary, the most recent amendment that you have submitted, is it true that this bill would provide greater specificity for behaviors relative to when one might be recalled? Is that, I mean, did I get that? Am I in the ballpark there?
Yeah.
Yes.
Okay. So then with regard to communities that have charters, and I served on a community on my local school, back then it was called school committee, now it's school board, for the city of Portland, in which we did have a charter. In that particular scenario, with this bill, there would be some defined parameters by where one would be able to recall a particular school committee member. Did I get that correct?
Yes.
Okay. So it couldn't necessarily be for, and I don't mean this in a flippant way, it couldn't necessarily be for somebody driving a blue Ford truck.
Correct.
Okay, thank you.
Okay. Any other questions or comments? Representative Solider?
Thank you. I think that what I'm trying to, what I appreciate about the bill is that by giving, like Representative Gramlich said, about giving that specificity so that if I serve on the school committee, which I did in Westbrook for 17 years, if I do something in Westbrook, I could potentially be recalled. If I do the same thing in Gorham, South Portland, whereas now what we have, with the charter communities and I know that a lot of work has been done. And I think that the charter communities that did the work around recalls or voting or whatever they did the work around usually resulted because of an incident or something that happened. So that they realized they didn't have something in place, so they needed to put something in place. And I think that this just, the way that I'm looking at this is built on that work that those communities did as a default because of something that happened potentially where they needed to put some parameters in place. And this is just like the next step. We're helping as a state so that the communities that don't have a charter and don't want to go through the process of a charter, because like you mentioned, we're seeing increasing numbers of incidents happening with school boards and outside forces that are creating some situations that are very concerning. So this is an opportunity to help those communities to build on those, which I appreciate that. I know that we did not in Westbrook have something in our charter related to this. So this would have been helpful for us if we ever did come across that situation.
Representative Sayer, did you want to say something?
Yeah, I wanted to respond to that. I recognize that there's sound judgment and merit to both sides of that debate of whether you exempt chartered communities or not. I have chosen this position in the bill that I've put in front of you primarily for the reason that Rep. Salisbury just articulated, that we have a great number of MSADs and SAUs that have a mixture of municipalities in a single school unit, in a school administrative unit. And if you have different recall rules for all the municipal components of that school unit, it creates a confusing situation for a school board to navigate and the public to navigate what process will govern, what rules govern if people want to initiate a recall. If we have one set of rules, everyone knows how it will be administered. And that's why I came down on one side, not the other, of an argument that definitely has merit on both sides.
Yeah, sure. Absolutely. Okay, thank you, Representative Sayer. Is the representatives from the Maine School Board Association present?
Thank you.
Thank you. Hi,
Hi.
good morning.
Good morning.
And I think the issue is really it would be helpful for you to, and I'm sure you've shared this at many different times, but your viewpoint on the amendment and your feedback to us on the amendment.
Sure. Yes, thank you. First of all, my name is Eric Waddell. I'm the Executive Director of the Maine School Management Association and the Maine School Boards Association. And I started that position just in July, so I didn't have the benefit that most of you have of having been involved in the first chapter of this discussion last spring. My predecessor, Steve Bailey, certainly was very actively involved in that. Robbie Feinberg, our government relations specialist, and worked very closely with Representative Sayer on this, along with some support from legal counsel to get some guidance on where we're going. So yes, we've worked very closely, as I said, with Representative Sayer on the version of this bill that you have in front of you today. And there's just a couple things that I might like to add as listening. So first of all, we did do some research on the number of communities that have a charter. There are 490 municipalities that have a charter in the state of Maine. It represents about 16% of Maine communities with a charter. That doesn't necessarily.
How many, what's the percentage?
16.
Okay, and how many communities are there?
So
there's 400 municipalities.
It's 80 of Maine's 400.
Right, okay,
okay.
That makes
more
sense. Okay, thank you.
Only 80 of those 490
Right.
have a charter, so representing 16%.
Right.
And I guess my point is that, of those 16%, not all of them have language in their charter that pertains specifically and explicitly to school board recall. So the association really feels, the Maine School Boards Association feels, and I recognize that they've gone in some cases full circle on this. and I've had the benefit, as I said, of being involved in the work with the Maine School Boards Association and Mr. Feinberg on this work since July, and it has taken them some time to come around and understand the benefits of having a bill like this one that's proposed to you now. I think the most important benefit that the association sees is that we have there are over 1,700 school board members in Maine. As Representative Sayer explained, they come from a variety of organizational structures. Some are municipal school units, others are SADs or RSUs, there are AOSs, there are CSDs, there are school unions, and our board members come from all of those organizational structures. So we feel at the association that having a consistent law pertaining to board recall would be fair to all of our 1,700 board members from across the state. And I agree with Representative Sayer that without something, what we're seeing at the association is, in many cases, a reluctance for people to consider stepping up and serving their local SAU in the capacity of a school board member of the school board, for that very reason, that they feel there's a sense of vulnerability, that they're all just one vote away from possibly being recalled as well, without some clear and consistent application of the statute. So I certainly, Representative Greenwood, hear your concern, and that certainly did come up during many of the working sessions that we had with the Maine School Boards Association's Legislative Committee. Many of them expressed that same concern, but in the end, they felt that the benefits of having a consistent statute across the state would outweigh the usurping of local control for those few districts in Maine, for those few municipalities in Maine that have a school board recall in their charter.
Okay, I understand that. And but as you said, not all charter communities have a recall provision. So my concern is I don't want to usurp that local control, and that this could still apply to charter communities that don't have recall provisions. And we could see how it works over a period of time. I totally understand the concerns. As I said before, well aware, having served in local government. My law partner just got elected to the Herman School Board. I asked him why he ran. I wasn't sure, other than he had kids in the system. I was surprised he got elected, even though he's my partner. So he still got elected in Herman. So there you go. But and he deals with these issues all the time in the meetings that they have. So, but I don't want us to be afraid of the voters either. Okay, and to put up too much roadblocks for accountability. But my major thing is I would support this bill, and I'm just letting my position be known, just my position, that I would support this bill as long as it applied to, in terms of charter communities, it applied to only charter communities that don't have their own provisions for school board recalls. That would still probably be close to 85 to 90% of the communities. And then we could see how it works before we supersede local laws already in place. That's my feeling.
Sure.
Okay. But I don't know, how does the committee wish to proceed? Representative Greenwood and then Representative Gramlich.
Thank you, Mr. Chair. I just have some more questions if I might. Do you have a sense of how many recall elections have occurred in, say, the last 2 years for the position of school board? How many were a positive outcome, meaning the recall passed? Just to see, what kind of a problem this is. Because I mean, I understand there's the threat of a recall, but then, to actually go through and actually, gather signatures, get it on the ballot, and then have it go out to the voters to see, can you say, just in the last 2 years, do you know of how many have occurred? As
I couldn't possibly give you a number on that, but we, our association could research that. The challenge there, Representative Greenwood, is that in many cases, the threat of a recall results in, oftentimes results in a school board or school committee members resigning just because they don't want to have to go through that, the process. That happens in some cases, and it would be difficult to gather information about that, but we certainly can reach out to our members, our member schools to gauge how many recall attempts or efforts have been initiated over the last year or two. Mr. Feinberg, our government relations specialist, who's been working on this bill right from the beginning, may already know that. He's unfortunately working on another bill this morning at another work session.
Right. I mean, just another, an earlier comment you had made about how there's a mishmash of, there might be multiple communities within a school district and some are chartered and some are not chartered. I don't think that's an issue at all, because I think those that are chartered, there's a defined process if they reference it. If they're not a charter community, they fall under current state statute, which says they can only be recalled for these reasons, that they committed a crime against the school. So I'm not sure if I see the concern here.
Right. I think Representative Sayer touched upon that, but maybe I can underscore it. So I came prior to my joining the association in July. I was the superintendent of schools in Kittery. Kittery is a municipal school unit. There's just one town. And so if Kittery did have Kittery has a charter, and if they did have a recall provision, it would apply uniformly to all 7 members of the school committee. That wouldn't be problematic. The challenge, of course, is that the community where I live is South Berwick. That's part of an RSU that has just 2 towns. There are I have roots as well in Aroostook County and Presque Isle, where the local SAD has 5 towns. And so the challenge there with a 15-member board is that if communities with a charter that has a board recall provision in it already is allowed to maintain that charter, that provision in their charter, then those 15 board members, say in SAD number 1 in the Presque Isle area, would all, several of them may have a different threshold for recall. And we believe at the association that they would create considerable confusion across the state. We believe at the association level that all of our 1,700 board members should understand what the state's recall provision is for them, and that it be applied consistently and uniformly.
Thank you. Representative Gramlich, you had your hand up, and then Representative Adams.
Thank you, Mr. Chair. And again, this Representative Greenwood kind of asked what I was curious about already. And I think you answered it, but because I can understand how there could be some sense of confusion if you've got multiple municipalities and folks who may live in whatever municipality serving on one board. Do you have a sense, so I get that. Do you have a sense of how many of those municipalities in the state that are in that position relative to having, let's say there's an RSU or an SAD that's got 5 different municipalities, that some of which may have a charter and some of which may not. Do you know what the scope of what we're looking at? How many that is? Am I making myself clear?
You are, yes. I don't have that data at my fingertips. My assumption is that it would be a small number. I think someone mentioned earlier that charters typically come with larger municipalities, and that those larger municipalities oftentimes are not part of an RSU or an alternative organized structure. They're municipal school units, which they would be then the members the recall provision would apply to all of them consistently. Again, I'll just mention that the association, if I may, we just believe that it would be helpful for all of our 1,700 plus members, board members across the state to understand and.
Did we get any, I don't mean to interrupt, but
That's
did we
fine.
get any feedback specifically from the charter communities? I mean, did we say, we're going to be passing a law that's going to overrule your charter? What are your thoughts about that. I mean, they may be separate from your 1,700 members. They're a subset of that group. And they're going to have their own separate issues. And they're usually the larger communities. Usually the larger communities, the charter communities
Yeah.
that have established through commissions or whatever, specific procedures to govern locally.
Yeah, Representative Sayer may have researched that or.
Okay,
or Mr.
but I'm just saying
Feinberg.
that's an issue in my mind is,
Yeah.
you know, what is their feedback? What are they going to say when we pass a law that basically nullifies part of their charter? And I know it may not be a big deal in the scheme of things, but you know that trying to straitjacket all these communities sometimes when they've developed their own local procedures, it can be a problem. So,
Yeah, I certainly understand local control is a priority.
Representative Adams and then Representative Toole.
But you keep on referencing, Representative Sayre represented the board meeting, then that's actually in my district they're referring to. So in my district, it's made up of several different towns, which have so many board members voted on that district. So we do have recall ordinances in place. And we don't have a charter, but we do have recall ordinances in place. My question is, I mean, you're trying to mandate this. I mean, I know for a fact this didn't even filter through the town I live in, not even recently asked or remotely asked to have anybody down there. So I know there's a lot of stuff going on with the school boards. I get that. But I'm all for local control, and this is going to be nothing but a mandate. And then looking at your association and the people that are involved, they can pick and choose basically, you know, who they want on those boards. That belongs to the people that vote to those boards for those towns. The state shouldn't decide who needs to be on what board for what town. So.
Okay, and Representative Toole, you had a question, and Representative Salisbury.
Thank you, Mr.
And then
Chair.
Representative Rollins, I apologize.
Thank you, Mr. Chair. And I hear a lot of the concerns about the charters, and I don't live in a bigger community, so I probably don't have the same appreciation others do there. But on the other end of it, I live in a smaller community, and we do get a lot of stuff passed down, and there's a lot of struggle to understand and comply and be educated about this law or this rule or that mandate. And there's a great conversation about what we ought to be doing, but there has yet to be a real constructive conversation about helping smaller communities out financially with all of this work, considering that now considering that we have a broad recall provision for municipal officers, a set aside for another process for charters, and now we're going to apparently set up a recall process for school board folks, and yet possibly another. So you can see where municipal clerks that are going to be navigating this recall process are going to be swamped with many different processes. And in a small town, that could be problematic. And I know this is a very complicated issue, and I got to give credit to Representative Sayre for bringing it forward. But I just seem to think this is a lot more complicated than folks realize.
Representative Rollins and then Representative Salisbury.
Thank you, Mr. Chair. So sitting back for a while and listening to the discussion, which tended to gravitate to local control. And I think we're missing the bigger picture. And I think the debate should be what's best for Maine now and in the future. Local control has been in my opinion, fudgeable argument, just like no mandates. We don't have mandates when we want them or don't want them, and we have them when we want them. And I think that there's merit to people who believe in local control. I think there are times that local control makes sense and doesn't make sense, and we can go around the barn 5 times on that. But in this particular case of recalls of people who have behaved on a school board in a manner that should come to the public for a decision if they continue, We need to look at this of what's best. Is it a uniform approach so that wherever you are in Maine, these are the set of criteria and rules that we apply? Or is it a mishmash and tiered between nuances of school districts or consolidated units and larger communities and all other? I personally believe a uniform approach to this system is best for the state of Maine.
Okay.
Thank you.
Yep, Representative Salisbury.
I'd like to request a corner caucus and requesting that Representative Sayre come meet with us.
Yeah, Representative Greenwood.
I don't think we're ready to vote yet or even talk. I actually would like to see if MMA would be willing to join us at the Horseshoe before the corner caucus.
Okay, is a representative from MMA present? Yes. Thank you very much, sir.
Thank you.
Oh, yeah, I'm sorry. Representative Adams had another question.
Real quick, you mentioned South Berwick. So South Berwick has students that go into Marshwood from Rollinsford. Now, you can't roll this law over to Rollinsford because that's a different state altogether. They got an interstate compact agreement there. Last I knew they did.
Yeah.
So again, how does that play?
In the particular case, Representative Adams, there are no board members from Rollinsford on RSU 35 board.
Okay.
Yeah, okay.
Thank you so much for
Thank
your
you.
time and your testimony. Representative from MMA, I think. Welcome. Oh, there she is. Hi there, welcome.
Good morning, Rebecca Lambert, the Maine Municipal Association.
Hi there, thank you. If you just want to weigh in on the discussion in any way, that's good.
Well, our members were kind of split on this issue due to local control, and some of our members do have charters, and they would have to change their charters if this did pass. So the Legislative Policy Committee did decide to be neither for nor against this.
Yes, of course, Representative Greenwood.
Thank you, Madam Chair. It was referenced that it's generally the larger communities that have charters, but I, in fact, come from one of the smallest communities and have a charter of Wales. And my school district, there's three communities, Litchfield, Monmouth, and Wales. Wales and Sabattis have charters, Litchfield doesn't. Do you see that as a problem? School board members are elected from their community. Do you see the mishmash as a problem are we searching for a solution? Is this a solution in search of a problem, or can you weigh in on that?
I don't know if I'm qualified to weigh in on that, but I would just reiterate that this does divide our membership. And I would think that most municipalities do look to their charters if they have one for these types of things, or I guess I would just say that we would like to see local control maintained, and that the charter, they follow their charters, I guess is where I would go with that. Sorry.
Representative Toole.
Thank you, Madam Chair, and thank you, Ms. Lambert. Following up on my point, which I know you heard, how would you advise communities around the state to navigate this whole process, given that we're adding yet another recall, or not adding, but having yet another wrinkle to the whole recall debate, whether it's town or school or what have you? And are you concerned that there will be some unintended consequences of having to learn how to or having to educate folks and get them up to speed with the law?
Thank you for the question. I believe there could be confusion if there is a mismatch of laws, that could come into play. But at the same time, the local communities know their communities best, and they are the best people to determine who should be on their school boards.
Representative Underwood?
This is just an observation, but if we get a new governor, and obviously we're going to get a new governor, and I wish that someone would sponsor a bill to abolish the educational department, the complete entirety, because it's none of the state's business of what the kids are, who they learn it from. That's a local control issue. And once we start down the road of absorbing local control into the state, and it's probably already been done, it's mandating across the state a certain value system. And that's not what this country was founded on. And with that, I'd like to say, again, I hope someone mandates a bill like the federal level is. They've eliminated, or in the process of eliminating, the Department of Education, and have just the legislature appropriate funds for any amount of education to the educational committee, and do away with a lot of this stuff. Thank you.
Thank you, Representative Underwood, for your always enlightening comments. I just want to, Representative Greenwood, you mentioned something I just want to make note of is that in search of a problem, clearly a problem has been identified because people have charters with recall process. So the problem has already been identified. I think what we're dealing with now is, so there's charter provisions that already have a recall process, and this is adding on a blanket. And so it's just trying to figure out the balance between those two, allowing the communities to deal with the problem they've already identified. And do we do that based on just charter, or do we deal with this from a statewide level? So just really quickly, I just want to have a corner caucus. I just have a question for Representative Sayer, and it shouldn't take very long. We'll be right back. All right, thanks everybody for your patience. Sorry to keep you all waiting. After some discussion, we would like to, or I would like to offer an amendment to this bill. After speaking with, the sponsor of the bill would remain as stated, but we would add a carve out for any community that has a charter that addresses recall provisions for school board members.
Second.
Did I capture all that?
Mhm.
And so, and how we're gonna play out the rest of today's meeting, just it's a little bit different than what we normally do. I'm just proposing that, giving that wording to our analysts. We're gonna keep moving forward with our analysis of the different bills, then give the different caucuses an opportunity to talk. And then we'll come back and vote on each of the bills, if that's okay. But I just
Thank you.
Yes, Representative Rollins.
Question on the amendment. I know it was discussed, and I thought we were bringing it forward, that there was the option for a community to opt in and keep their charter as is, or if they had a vague process, they could change and follow the state, this new law. Is that just implied naturally, or we?
If you turn your microphone off, I can respond.
Knowing
So what this would do is this would exempt them from having to be mandated to follow this new law, but certainly any community that wishes to change their charter or wishes to follow a different process could do so. But the amendment would say that we are carving out any community that already has a charter in place that addresses the recall of school board members.
So, Madam Chair, we're going to go forward.
Yes.
Okay, I was going to ask if we could go to 1744, which is the state civil service system bill. So I know there's been some discussion on that. And I know there are a number of people here who want to talk about it. Go right ahead.
Thank you, Mr. Chair. I do have an analysis if you'd like distributed for this
Sure.
bill. Okay.
This is Representative Rollins's bill.
Yes.
I just wanted to say that.
Yes, it is.
Go right ahead.
Thank you, Mr. Chair.
Yeah.
So we have coming around an analysis for LD 1744, an act to modify provisions of the state civil service system governing employee recruitment and retention. I will note this bill had a public hearing on May 5th, 2025. Today is the first work session on LD 1744. I would kindly defer certainly to the sponsor for any updates since the public hearing. And if it is helpful, I do have an analysis presented here for the bill as printed. Would it be helpful to proceed with the analysis of the bill as printed?
Well, first, Representative Rollins, why don't you update us on where you are? And
Yeah, it's pretty much as we see it. There've been no updates. I've not aware of any proposed amendments. And something happens live here on the Horseshoe, but I think we're good to move forward.
Thank you very much. I will proceed. So this bill makes the following changes to the laws governing recruitment and retention adjustments for state employees in the classified service. For one, it changes one of the criteria for authorizing payment of a recruitment and retention adjustment to add to the existence of high turnover or long-term vacancies within a specific department in the relevant occupational classifications or job series. It changes another of the criteria to require that reasonable recruitment and retention efforts have been attempted and have proven ineffective at the current levels of compensation. It provides that payment of a recruitment and retention adjustment may be authorized when an occupational classification is in a job series or job family within an occupational classification entitled to an adjustment, and the occupational classification would suffer from either salary compression or salary separation as a result of payment of that adjustment to the other occupational classification. It requires the labor market adjustment to be reviewed at least every 4 years in alignment with market pay study conducted by the state, and the resulting recruitment and retention adjustment applies to employees hired subsequent to this review. It provides that if the committee formed to evaluate each request from an agency or bargaining agent for recruitment and retention adjustment agrees on the appropriate adjustments, the committee must provide a report recommending and documenting those adjustments. If the committee does not agree on the appropriate adjustments, the matter must be submitted to a neutral third party for a final decision and report. Number 5, it requires the Department of Administrative and Financial Services, Bureau of Human Resources, to prescribe the forms to be filed with the Bureau to request a recruitment and retention adjustment. Number 6, it removes language that authorizes payment of a recruitment and retention adjustment when the relevant occupational classification or job series has a clear, geographically definable labor market within which the state must compete. And for 7, it provides that if the committee that reviews the adjustment agrees on the appropriate adjustments, the committee must provide the appropriate persons with a report recommending and documenting the adjustments. The public hearing information has also been included. For a little bit of background information, as we know, LD 1744 is a carryover bill, and it was one of 3 bills governing state civil service employees considered by the committee during the first regular session and first special session of the 132nd legislature. LD 1265, which was an act to amend the laws governing public employee market pay studies and comprehensive reviews of the classification plan for state service positions, was held by the governor at the end of the first special session and will go into effect 90 days after the final adjournment of this session. LD 1539, which was an act to create a state employee compensation stabilization fund, was carried over as enacted on the appropriations table. As a housekeeping item, I will note that much of the testimony the committee received on 1744 also included some testimony on 1265, which I mentioned. So you may note that your folders, Liv kindly provided your folders for 1265 in case any of the testimony for 1744 was grouped or included in the filing system way in 1265. For relevant statute, you can see that 1744 amends Title V, Section 7065, subsection 2D, which specifically governs the payment of recruitment and retention adjustments for state civil service employees, and that statute has been appended. Additional information that was provided to the committee at the public hearing. In the testimony from both DAFS and MSEA, it was noted that pursuant to a settlement agreement between DAFS and MSEA, DAFS commissioned an outside entity to conduct a comprehensive review of the state's classification system, and the consultant's report is expected or was expected by December 31st, 2025. Deputy Commissioner Trundy noted in the testimony that DAFS and MSEA plan to meet to bargain on or around May 1st, 2026, and DAFS is required to submit a report to the legislature by September 1st of this year, which details the process, the study's findings, and recommendations. If it may be helpful, I won't go over them now, but I did try to break down, based off the testimony received, terms that are used. Some of the terms below, job classification, job series, or job family, are referenced or used in the bill directly or the testimony. So if that may help the committee as you consider this to have an understanding of what the definitions of each of those mean, that may aid the committee in understanding the testimony and the bill as printed. Potential issues for consideration. There were provisions in the bill raised by DAFS for the committee's consideration. Some of the provisions in the bill were either originated with the department or the department expressed agreement with. That was raised in the testimony, and I do have that if the committee wants that information. The following were concerns raised by the testimony for the committee's consideration. Eliminating the word only on page 1, line 8, that is in section 2DA. Current law stipulates that authorization for the payment of a recruitment and retention stipend only exists when 4 conditions are satisfied. DAF stated the concern that removal of the word only would cause confusion for the rest of the section as printed, to lose authority and clarity and create ambiguity for decision makers on the legislative intent. DAFs raised concern with eliminating criterion 2 in 2DA2, which is on page 1, lines 13 and 14, which currently reads that struck through section there. DAFs expressed a concern with eliminating this provision and noted that the Bureau of Human Resources is open to discussion on clarifying language. Eliminating the word all and replacing it with reasonable and in criterion 3, 2DA2, which is on page 1, line 15. The current language reads as follows, and the testimony noted concerns about future litigation and how the proposed change could add confusion to existing Bureau processes. The new proposed section in 2DA1, which would permit payment of a recruitment and retention adjustment for an occupational classification when that occupational classification is in a job series or job family with another occupational classification entitled to an adjustment pursuant to that aforementioned criteria, and would result in salary compression or separation as a result of the authorized adjustment. That language is outlined in page 1 and the bill, lines 22 and 30. DAF stated a concern that such a provision would, what they stated, exponentially increase the cost of recruitment and retention stipends and eliminate the underlying reason for them. The use of the criteria or certain language in the bill was also raised as a concern, such as job family, which the department raised in the testimony would be overly broad and statutorily vague. That language appears on page 1 in the bill, lines 23 and 24. DAFs had expressed a concern that the bill's description for the term salary compression is absent or does not specify what an acceptable compression rate would be, noting that the Bureau has accepted compression rates at or lower than step 4 of the promotional class. In changes to the committee formed under 2DC, that is in section 1 of the bill, starting on page 1, line 39, to evaluate recruitment and retention adjustments, the department cited a concern that the proposed revisions add an additional step with increased costs. There were also 2 pieces of testimony submitted by MSEA on LD 1744, and those are the ones that may appear in either folder. In the first piece of testimony submitted by Tom Feely, the general counsel of MSEA, they expressed the concern that the statutory process for recruitment and retention adjustments under Title V, Section 7065 is broken, and cited concerns around accountability and objectivity in the current statutory process. They also stated in their testimony concerns with instances where the Bureau did not respond to requests from MSEA to convene the committee under the current statutory provision in Title V, Section 7065 to evaluate recruitment and retention adjustments. On the next page, MSEA also provided in the second piece of testimony was submitted. That was submitted in response directly to the state of Maine's 2024 market pay report and outlined 6 primary concerns, including concerns with some of the data collection practices used for the report. The testimony specifically cited a concern that the state report was overrepresenting classifications that have already received market pay adjustments, citing the concern that skewed the overall average reflected in the report. And they also cited in their testimony a concern that the vast majority of classifications in state government do not presently have pay stipends, but the 2024 market pay report included overrepresentation of classifications with large market pay adjustments already applied, which they stated automatically skews the overall average closer to the market average. So those were the concerns raised for the consideration of the committee in the testimony. I raised just a drafting consideration for the committee, whether or not the committee wants to consider further clarification to understand the intent or applicability by the committee of certain terms used in the bill, such as reasonable, and I noted where that language appears, salary compression, also noted where that appears, and lastly, salary separation. At this time on Monday, not yet determined by OFPR for fiscal information.
Any questions? Representative Rollins.
Yep, I mean, yes. Thank you, Mr. Chairman. I want to just focus on something that I'm not sure Kristen even touched on because she's a fast reader and it's a wicked skill set. But this system requires that a committee be formed and that an agency or a bargaining agent can submit a request And that can be only awarded under very strict conditions. And I want to highlight for you, there's a high turnover rate existing. There is a classification of jobs as clear geographical defined labor markets within the state which they must compete. All reasonable and appropriate recruitment and retention efforts have been attempted, and comprehensive verifiable documentation of labor market compensation levels must be met. And this documentation must demonstrate that a labor market disparity exists. Those 4 criteria have to be met in order to submit and have consideration. So this isn't willy-nilly. It's very measured, and that's important. The next thing I have, Mr. Chairman, is some of the concerns that she just wrote. Tom Foley is here, and I'd like to request that he may come forward and we can question him.
Sure.
Sure. Thank you.
Can I just ask a question?
Yeah. Yeah, go ahead, Representative Salisbury.
Thank you, Dave. Just a quick question about the other bill that was similar, that it was 1265, is that right? And that bill that was Representative DeLog, that bill is being held by the governor, is that right?
Yes,
Trying to find
the
that.
sponsor, I also do have that if you're interested in 1265, held by the governor, was held by the governor. It was not recalled or vetoed. So it technically, was chaptered, became law on Sunday, 1/11. But please note that that law will not take effect until 90 days after the final adjournment
Okay.
of this section. 1539, was the other bill that I had referenced. And that one is carried over as enacted on the appropriations table.
Okay, great, thank you.
Go ahead.
Is there a specific question? or-
Yeah, Dave, Representative Rollins, did you have a specific question?
So just introduce the concerns that are outlined in here
Okay,
and your feedback on those, and then we'll open up people for questions.
okay. I'm Tom Feely, General Counsel for MSEA. I think this is the 4th year in a row I've been before this committee on either this bill or a very closely related bill. And this has been through multiple iterations. It's been through a labor management process that went on in the fall of 2024. And, I think this is our best attempt at coming forward with a compromise bill. Before I get started, I just want to give a shout out to the fabulous staffer you have here. She did a great job summarizing the bill, the various terms, and, where we are.
She does a very good job.
Yeah,
Thank you.
excellent. So in terms, I think our big concern, as I said last year, is about accountability and objectivity. We've had over, if I could direct your attention to, I think it's section C of the bill. It states that a committee must be formed to evaluate each request from an agency or bargaining agent for a recruitment or retention adjustment. So a committee must be formed to evaluate each request. Over the last 3 years, we've had, I think, 7 requests, and 5 of them have just been outright ignored. When I've asked, a series, 2 different directors, and I finally got an answer that they viewed our requests as frivolous, quote unquote. And this was about Office of Child and Family Services. We had a request for recruitment and retention stipend for ancillary staff, not the caseworkers, but ancillary staff. And I think we're all familiar with the struggles of OCFS around staffing and the impact that has on the children being served. And then, there's been other places as well, but, the fact that we can't even get a meeting when the statute is crystal clear that a committee must be formed in each and every instance, to us shows that the system is broken. And so that's kind of the thrust of this final, the second half of the bill, which is to have a third-party neutral be the ultimate decider on this. And that's the reason why we have proposed this language. Regarding the adjustments to the criteria, so let me see here. So in the second criteria, the relevant occupational classification or job series has a clear geographically definable labor market within which the state must compete. compete. That's about as clear as mud. And we also think it's somewhat redundant because in the final criteria, number 4 talks about comprehensive verifiable documentation of labor market compensation levels within the defined labor market. So it's already in there that we're talking about a defined labor market. We don't need a separate criteria for it. And it's just historically, it's been a area of confusion and no one's been able to give a good definition about it. Some of the other issues that were raised about salary compression and salary separation. Salary compression is a term of art. It's my understanding that the Bureau's definition is as is said here in the summary, that it is compression at or lower than step 4 of the promotional class, meaning if you have somebody who's going up the top of the scale, the top of their scale should be below step 4 of the next higher person. And the idea is you shouldn't have supervisors making less money than the people they're supervising. And we see that across state government, whether there's stipends or not. The compression is just a huge issue and it's something we've been working to address in a variety of forums. We just want to make sure that when we're going through this process, getting recruitment and retention stipends, that we're not exacerbating the problem of compression. There is also the number 3 of the criteria where we struck the word all and put reasonable and appropriate recruitment and retention efforts have been attempted. This goes back and I apologize if you've been on this committee for a few years because you probably heard this story 3 or 4 times. Well, back in 2018, we had Department of Public Safety 911 callers who put in for a stipend. They were, the geographic market, the labor market was clearly defined and they were clearly underpaid. And the department's response was, despite the data showing that they're underpaid, we're not going to give an adjustment at this time. And instead, we're going to give you a service dog and we're going to give you a relaxation pod, right? Instead of actually addressing the pay issues that are required under this statute, they came up with 2 other recruitment efforts. It's our position that that's not reasonable. And in terms of, what that means in every instance, that would be in this process, the role of the third party neutral to decide what reasonable measures have been taken. Again, I don't think a room for people to go cry in after a particularly difficult shift is a reasonable alternative to pay increases. So I don't know if folks have additional questions. There's a lot here, but that's kind of our overall impression. Yeah.
Thanks. I have a couple of things. One, based on what your current comment, I think that I do a lot of work with public safety in EMS. So I think that saying that giving them more money as opposed to a room to cry in would be helpful totally diminishes the work that they've already done. And I think they would be offended, I would guess, that giving somebody more money to help with their mental health issues related to their work isn't adequate either. And I do just have a question here about line 3 when it says reasonable and appropriate recruitment and retention efforts have been attempted and have proven ineffective at the current levels of compensation. I'm just wondering, how is that measured? Who determines that the efforts are ineffective?
It's what the well, if I could address your first comment first.
Please.
I'm not trying to minimize the severe mental health impacts that occur. What I'm saying is, this is the yes and thing, and where there's market data and high vacancy rates showing that a stipend is appropriate, then it's a misdirection to say, here's some mental health stuff to help you, but we're not going to give you any more money, but here's a service dog. And it's and this is coming from the workers who are saying, we can't keep people, we could go to the city of Augusta and make more money for a much less stressful job. So yeah, it's a yes and thing. But in terms of who determines whether it's reasonable, I mean, that's the role of the committee. And ultimately, in this process, the role of the objective third party to determine what is reasonable.
Okay, other questions? Okay. Thank you. Deputy Commissioner Trundy, did you want to come up? Thank you.
Thank you.
You're welcome. Hey there, welcome.
Thank you very much.
You want to, I don't know if you want to introduce yourself
happy to.
and I guess respond or go over this, whatever you think is best.
Yes. Good morning, I think. My name is Anya Trundy. I am the Deputy Commissioner of the Department of Administrative and Financial Services. And the Bureau of Human Resources is under our department. So I think that what I would like to say about this bill is that recruitment and retention is a valuable tool that the state has to address very specific circumstances in which there is a demonstrated need that we are having trouble recruiting employees. And my concern about this bill is that in a couple of sections, it really seeks to expand the focus of the efforts beyond where there is a specific demonstrable recruitment and retention problem. And that has the impact of raising the fiscal cost of these efforts when we're not looking at specifically what the position, like just the positions that have a recruitment and retention problem, because just because you have a recruitment and retention problem in one position does not mean that you have it in the position above it or the position below it. And it's totally valid to say that we need to look at how a recruitment and retention stipend would affect the positions that are around it. But it does, and whether there becomes wage compression as a result of a stipend, because a stipend absolutely could create a domino effect, right? Of creating a problem where if you raise the wages for somebody and they are now making more or very close to what their supervisor is, that changes how their supervisor feels about how they're being compensated and your ability to retain them. So we do look at those things, but I also would say that we have a history and an experience where there has been an attempt to broaden what we are looking at beyond what the state thinks is reasonable to address the actual problems at hand. We're absolutely willing to address the problems at hand and look at them seriously. I would say that it's a misclassification to say that we have not been responsive to requests for recruitment and retention committees, but there are some specific examples in the last couple of years where the requests have come in and they've been related to, say, federal positions where there's a hiring freeze because there's not federal funding. And so we can't hire those positions. There may be vacancies, but it's not because there's a recruitment and a retention problem. It's because we don't have the funds to hire those positions. So those would be situations in which we would outright at the start of things say, that's really not an appropriate situation to put through this process because the position's being held vacant due to a lack of federal funding. There's another instance that I know of where we made an adjustment to a position and same day or next day, MSCA filed for a recruitment and retention adjustment on that exact same classification. We had just come to an agreement about it. That was another one that, where we said, we just came to an agreement about this. So I think we've got some frustration about the recruitment and retention process possibly being used for not a targeted solution. And so I think there's room for agreement within this bill, but I think there's some guardrails that need to be put on some of the language. Where, you know, maybe we can give a little bit on what the criteria is, and to get ourselves into discussions. And have the door not be shut. But I also think, right, there's got to be some threshold, there's got to be some reasonability up front of why you're going to go through a process like this. The other thing is that, you know, a lot of times the disagreement in recruitment and retention stipends is about the amount or the percentage. The example of the public safety workers was, and the dispatchers was brought up. My understanding is that the original proposal by MSCA was a 40% stipend. They currently had and I'm going to say, we revisited this in 2022. They often go back to the negotiations around a recruitment and retention request that were done under the prior administration. In 2022, though, we looked at this and there was a request for a 40% stipend. They currently had a 15% stipend. Ultimately, I believe 30% was agreed on. And so the disagreement is often around the amount. We've got a responsibility to make recruitment and retention adjustments within resources available. So a big question about whether we're able to make recruitment and retention adjustments is based upon what money is available within the department to fund them. If there isn't available money in the department to fund them, there has to be an appropriations request to fund the additional amount. We've talked about the ferry workers before. Rates were increased on the ferries to ultimately fund the increases for recruitment and retention purposes for the ferry workers. So there's a bunch of different things that have to be considered with a recruitment and retention stipend. And so we have a lot of responsibilities in this that are, they're complicated. They are beyond just simply giving a worker more money. But we are incredibly willing to recognize when there are recruitment and retention problems. It is not in the state's best interest to have vacancies that we can fill if we make recruitment and retention adjustments. So I guess I will leave it there.
Thank you, Representative Greenwood.
Thank you, Madam Chair. Thank you, Ms. Trundy, for being here today. I had my hand up earlier and then you answered the questions I was going to ask about. Give me some examples of recruitment and retention that have gone good, that have gone bad. But I guess, you answered that, but more importantly, how much discussion has there been on this bill since last year?
There hasn't been any discussion on this bill since last year.
Can I clarify your question? Since we adjourned in that session, okay, I know that you guys have had similar bills in the past. I just want to clarify.
No, I was just, I assumed if this was a carryover request, because it needed to be worked on, that there would have been something worked on since we adjourned last June.
There was a public hearing on this bill last year, but this is the first work session that you guys have had on the bill.
Question, yes, Representative Rollins.
Thank you, Ms. Chairperson. I do not interpret as the sponsor of this bill that this came forward with a critical complaint about DAFs. It's an attempt to try to find those spots that need to be ironed out so that it goes smoother. Having been involved in municipal government for 17 years, I'm familiar with and participate in collective bargaining. And it's very typical that numbers go from here to here and you settle somewhere in between. So I didn't see that comment as being outrageous. I think it's part of negotiating a request. This bill has tried to offer independent observation and decision-making or review, a committee to come up. What input can you give us from your side that would make this a more effective process?
I think I would agree with you, Representative, that parties starting on two ends and finding a place in the middle is how negotiation works. I also know, having experience with various appeals processes across state government, that a lot of times appeals processes are used just simply to try a different venue, or to take it to an outside arbiter when and not put the effort in to make it to coming to the agreement. And so I think our concern is that we think that we have engaged in this process honestly over the course of this administration, and that we're willing to talk about where there is where there's room for improvement. But I'm very worried about a situation where everything defaults to a third-party arbiter, because the third-party arbiter doesn't have a responsibility to the state fisc. A third-party arbiter is going to make that decision in a vacuum. They're not going to be concerned about whether the department can or cannot pay for a recruitment and retention stipend within existing revenue. They may not be inclined to take intermediate steps. I'll just use as an example, right? Like, starting at 40%, if you can accomplish it at 30%, and your recruitment and retention problem goes away when you create a stipend at 30%, then you've done enough. You didn't need to do the additional 10%. If 30% doesn't work, then there's no reason that we can't come back and say, well, we tried 30% and 30% didn't work. Looks like we need to go higher. But those determinations are also frequently based upon, what is market for that position? What do we have to accomplish as a wage to be competitive with the private sector, other public sector, that sort of thing. We want to go as far as we need to go to eliminate the recruitment and retention problem with the position. But we don't want to go beyond that, because that is money that gets used for other programming within a department. Everything's coming out of the same pool of money. So I guess that's what I would say.
So again, I'm not really interested as a first term representative of the frustrations from the past.
Yeah.
Well, I'm interested in how can we make it better moving forward? And those are valuable things to bring forward to make it better. But I would like to have more of a optimistic conversation about how to make it better, understanding the employees are going to naturally represent their side of the discussion and want only fair judgment. And I think this adds a layer of impartiality. I'm a professional appraiser. I have to be objective, impartial, and independent between the bank and the lender. That's an important position. And I think that the employees would like to have that. I would think the state would want to have that. I think it increases morale. I think you get more productivity. So that's my aim as sponsor of this bill, to find that sweet spot. It won't be perfect. I'm not going to say I'm going to eliminate frustrations in the bargaining process for retention and recruitment, but I think that both sides have input. If we can get better input, we got to bring it forward pretty quickly, because we got to do this by the end of the month, but we're open to that. And I'm sorry for frustrations in the past. We should learn from them and move forward and you've expressed that there's stuff that you can work with, let's do that. Do you have any amendments in mind right now, or any processes that would, from your side of it, make it better?
I appreciate that. And I would also like to express that I would like to look forward to how this can work better. I think putting some guardrails, particularly on that section of the bill that is about going to arbitration, about it not just being that any time that the parties fail to come to an agreement, because that's rather broad. I mean, that's just an instance where not coming to an agreement can sometimes be a valid thing. But I would say that perhaps there are certain criteria that should be met in that circumstance, or maybe there are things that shouldn't be subject to arbitration. For example, failure to come to an agreement about the dollar amount of or something like that. So I would put some guardrails on that, so it can't just be used simply on the basis of we're not coming to agreement, we're taking it to a third party arbiter. I think that's a very quick jump to make.
So I hear you. And I've been in that position representing the city of Augusta against very strong unions. You haven't dealt with a strong union until you dealt with firefighters.
Yes.
Right, Joe? And that would be a nice world. But we're dealing with collective bargaining, and that's a tool that all unions have. You're not going to eliminate that, but good faith negotiations hopefully can prevent that. So I understand your frustration, believe me, firsthand. But I don't think that's, throw this out because there's arbitration in the background. And then if there's no arbitration, then who decides?
Representative, I don't want frustration to overshadow this, because right now at this very minute, in 2025, there are 4 committees about recruitment and retention that have been approved by the State Human Resources Officer, where we are working on solutions. And the other thing that I will say is that there were 73 classifications that had stipends attached to them in an agreement that was come to last May. So I think there is a lot of work being done to have these conversations. I would like to keep that work happening in good faith rather than jumping to a third party so quickly.
Okay, I hear you there. If you have an amendment.
And I don't think that, I guess I would also just say that historically, we've found a lot of agreement around recruitment and retention in the past.
That's perfect. And the goal of this bill is to do that and to pass it. So if you've got something that will enhance this, please bring it forward. And other than that, I've got to turn this to the committee for a vote. And I appreciate here's some optimism at the end of our discussion now. But if we have a firm amendment that we should put in here, please bring it forward.
Okay.
I just want to point out that I don't think it's entirely on Anya to bring forward an amendment. I think it's more of an opportunity for the two sides. It's not inherent on her to bring forward an amendment. I think if anything, if we look to discuss potentially tabling it for another week for the two sides to get together to work on something, but I don't think it's inherent on just her to bring forward an amendment. I think both sides need to have sort of a compromise. I just want to wait because I think Representative Farren had a question.
Yeah, I would just, in one of the criteria you were talking about, Representative Rollins, the high turnover rate, is that a specific rate in the state of a 20% or 30? Is there a certain place where they say, oh, this is way high turnover in this section? Didn't know if there was a certain rate.
I I don't know if there's a certain rate, but I do think there's also, the high turnover also goes hand in hand with having nothing else have kind of worked to address the issue that you have vacancies. You can certainly see high turnover rate. We keep turnover metrics. So you could see it across different positions. You could see if a particular classification had much higher turnover than kind of what is the state average at a certain point, right? Like there are going to be things that aren't necessarily position specific that could cause an increase in turnover across state government. And there's all kinds of different reasons for turnover. We deal with turnover because of retirements. So turnover because of retirements isn't necessarily an issue. If we have trouble then getting people into those positions after those retirements, we've got a recruitment issue, probably. But so you have to look at the specifics of each situation, and but I think part of it is also are those vacancies kind of obstinate and unmovable? Has looking at changes to the job descriptions or sometimes that really makes a difference. You update the job description and suddenly it clicks more with people, or it has a lot more appeal. Also, a lot of these job descriptions don't get a whole lot of attention until they're vacant, and the jobs have morphed over the course of somebody holding them for a long period of time. And the job description that worked when they were hired in 1995 just it isn't what the job is anymore, and it may not have the appeal. So there's a lot of revamping that gets done too as initial steps. And sometimes it's very appropriate to reclassify a position based upon the position having changed while somebody was in it for a long time. So that's the type of stuff that we like to look at first, to see whether the vacancies can be addressed through that before we throw money at them.
Thank you. Representative Gramlich.
Thank you, Madam Chair. Thank you, Ms. Turney, for being here. Excuse me, I've got a little dry. It's dry in this room.
It's dry in all the rooms.
Exactly. I just wanted to just kind of put a finer point on a question that Rep. Rawlings brought up, and I don't remember if I heard you answer. Currently, when you have a situation where there's disagreement with whatever the case may be, who's the current arbiter?
Disagreement in a recruitment and retention.
And with pay as well. Who makes, if there's disagreement, let's say between DAFS and MSCA, for example, who's the current arbiter?
So if there's, in just a general instance, if there's a failure to come to an agreement, I guess at a certain point, there could be what it is now is a mutual decision to go to arbitration. It's both parties recognizing that they're at an impasse rather than, I think, kind of like unilaterally pulling that lever.
Understood, and that makes perfect sense. But in those situations where both parties are, unilaterally agreeing that that's the direction in which they want to take, how is it determined who the arbiter is?
Who the arbiter is?
Yep.
I think it varies by instance, but a lot of times it's assigned by and I think most commonly assigned by the Maine Labor Relations Board. There's a pool of folks who are mediators and arbiters that they assign to those tasks.
Thank you.
Representative Greenwood, did you?
Thank you, Madam Chair. Do you think there's fine tuning needed on this bill, or are you ready for the committee to vote? Is there negotiation that you would like to see occur? Or is what's before us an end all do all?
I think that there is fine tuning that can happen. I think there's a possibility for compromise. I think I can see where we can give. but also that needs to be a conversation where the other side of this conversation can see where they might be able to find some understanding with us as well. But I see that potential within this. I'd like to have the sponsor involved. I mean, I'd also like to bring it back to bring it back to the committee. I don't think a situation in which, it's just a matter of, the state and MSBA finding agreement. We're having some trouble with that at this exact moment, just to be quite honest. I am committed to trying to do that. But all parties have to be willing.
I just wanted to ask you a couple of clarifying questions on this for me. In the summary of the bill, that it talks about the request would be, the labor market adjustments would be reviewed every 4 years. What currently happens? How often? Is there a current prescribed amount?
So there's currently a market assessment that it's newly instituted within the last 4 years. We've done the first one, in which, but it's required in statute. We've committed to doing it every 4 years, to doing a market rate assessment. And so that in statute is also structured in such a way that the information is set to come to the state and to the union at a time that would feed into the collective bargaining process, so that also these concerns could be raised as part of collective bargaining. But we've set it up as a 4-year process, so that rather than getting in the situation that we were in where that assessment wasn't done for 40 years, we're doing maintenance work on it on a routine basis. Okay. And it's also, it's a thing that we look at consistently as jobs are being reclassified and reposted and stuff like that. It doesn't require that work in BHR doesn't necessarily require a recruitment and retention committee. It doesn't require collective bargaining to be happening. Like some of those adjustments can just be made through the reclassification process.
Okay, and the other question was, in the bill, the request or the part of the bill says require staffs to prescribe the forms to be filed with the Bureau to request recruitment and retention adjustment. Is there no forms now, or what does that mean exactly?
I think that this is probably the part of this bill that could most help the process overall, is that at this moment in time, the requests they're made via email. They're free form. And I think formalizing the requests and having documentation that requires certain arguments to be made up front and stated, and what the evidence is that's being brought forward to indicate that there's a recruitment and retention problem. I think that's hugely helpful. I think it's helpful to BHR. I think it's helpful to employees who think that there's a need for a recruitment and retention. I think it's helpful to the departments. I think it's helpful to the union. Like it sets very clear expectations about what the process is and and kind of like, what do you got to prove as a case?
Okay. But that's really helpful. Any other questions? Yes, Representative Toole?
Thank you, Madam Chair, and I kind of want to follow on what the representative from Wales had suggested, and not really to go back, but the observation that, in a way, that this has been puttering along for 6 months and there doesn't appear to be any movement. But also, I question whether we can get there in a week or whatever the time frame is, but at the same time, would you be open to scrapping the rest of the bill and just focusing on that last provision to get these forms in place as a way to do a small step that it sounds like might have some impact on the overall issue.
I'm willing to have I'm willing to have the conversation about the entirety of what's in the bill currently. I will say, I think part of the reason that the discussions did not occur during the off season is that collective bargaining was happening during the off season. So, both the state and MSCA were differently engaged with each other. I'm not part of collective bargaining, so I feel like I can come at this with a fresh and different approach and kind of hopefully not the baggage that that may be mired in currently. And so I'd like to give it a try, having the discussion about kind of all of the pieces of the bill currently.
Okay, thank you. Any other questions before we move on? All right, thank you so much. I appreciate your time.
Welcome. Thank you.
All right, so we're gonna move on to our, yes. Sure, yeah, we'll take a 5-minute break. Let me just,
You're in the same building, so you, oh, no, she's.
All right, thanks everybody for your patience. We want to move on now to LD 1969, which is an act to amend the Maine Revised Unclaimed Property Act. And we have received a bunch of information from our analyst, and thank you, Liv, for passing all that out. So we'll go ahead and take it from there.
Thank you. Thank you, Madam Chair. For as a quick housekeeping item, I'll let you know there was about 5 materials that were passed out. You'll see first was with my kind of horrible handwriting at the top. I apologize. Previously distributed materials is a copy of the bill analysis that we considered on May 21st, and I'll go over kind of where we left off, but just for an orientation of materials, you'll see in pink, this may already exist in your folder, but I reproduced what was passed out at the work session that we had on May 21st, 2025. So all the materials are here. Since the conclusion of the first regular and first special session, you also had kind of in a golden color in your packet, a copy of Chapter 45, the Maine Revised Unclaimed Property Act. At the time of the work session, any changes that went into effect or changes to any provision of law and that have been updated. That's why your a new packet has been passed out, but it's still the same Chapter 45, which pertains to this bill today. I won't speak to these materials when I briefly go over them, but I do know that the Treasurer's Office did provide, which was emailed to the committee in color copy, a copy of the most recent or current amendment for the committee's consideration today, as well as it appears a memo perhaps has already been also been provided from the Office of the State Treasurer for your review. But as a quick housekeeping item, as I mentioned, we had a public hearing on this bill on May 19th, and then a work session on May 21st, 2 days after our public hearing. So at that time, the committee ultimately determined at the work session that more time was needed to consider the concerns raised in the testimony by stakeholders at the public hearing, and asked the Treasurer's Office to work with stakeholders over the interim. So the amendment that has been distributed has been prepared by the Treasurer's Office in response to that request, reflective of the work over the interim, and that was electronically distributed last Wednesday. I would kindly defer to either the sponsor or the department for an explanation of their amendment and the changes proposed since the last work session. If it may be helpful, I'm happy to go over the analysis, but it is my understanding some changes from the analysis of the bill as printed may have taken place. So happy to proceed as the committee may direct at any point.
All right, thank you. And we have our state treasurer here, Joe Perry, if you want to come up and talk about or whoever wants to come up and talk. We want Jeff. And Jeff, please welcome, come right on up. And if you want to go over the amendment or any information that we need to have.
Thank you. Oh,
Sorry, that chair always does that.
It's just a surprise. So my name is Jeff Chakowskis, Assistant Director for the Treasurer's Office. And yeah, I'm happy to speak about the changes as we worked with about a bunch of other entities who have expressed concern back in May during the meeting. You know, one of the I'll kind of go in order here. So
Okay.
We just kind of maybe start in the beginning.
Yeah.
Because
Yeah.
there's a lot of red on this.
okay, yeah, there is, and a big part of that has to do with virtual currency, and so I can start with that.
Sure.
So there was a couple areas of concern with virtual currency that we had proposed. Originally, it was set for a liquidation of those currencies by the holder before they come to our office. And so that Treasurer's Office doesn't have to have a custodian and staff to manage those property types. And that was generally where we were leaning even after the last work session. However, in the fall, the Treasurer's Office was put in touch with the state of Oregon, who has taken over a different approach to virtual currency. And while theirs is not exactly what I think would work for Maine, and it's experimental for them, I think that it brought a good place for us to move towards in compromise with the other parties who have raised concern. So within that, there's a lot of changes. Most of the red here is around the virtual currency. And so the changes do is it allows for the option to receive the currency in its native form as long as there's a feasible and reasonable way to do so, but also has within the statute the ability for the to direct holders to liquidate the shares if that becomes the case. And I think what helps with that is we have both options available within statute if adopted, and based on best policy, as more information comes to light, where all states are kind of just getting their toes wet in this entire process before they decide if they want to jump in the pool. We can work through some of what is best for the state and its constituents and the owners in terms of cost, and what is, and of course, what is best for the owners overall. The difference that we have from Oregon is looking to treat virtual currency as a safekeeping. They're looking to actually take people's secret keys that are with the account and hold the account, not transfer the funds. I think that brings a lot of questions, like what happens when the owner has the secret key and then they're able to access their account while the state is saying that they have possession of it. And so that's where I didn't want to get into that, but I think treating it similar to a security, but then providing the options within statute, and then with assessment in the industry, similar to what many other states are doing. Perhaps administrative rule can help provide what the best option is at that time, which may change in a couple of years as states determine more information about the best way to manage unclaimed property. Individual accounts are on the surface pretty easy to identify and manage if you understand the cryptocurrency world. Unclaimed property puts a lot of wrinkles into general practices, and we find that there has not been a party in the industry that really understands unclaimed property and virtual currency to be a good custodian at this time. The only state that has received virtual currency is Washington, D.C., or state, I guess use state loosely. And for them, they're only able to accept the property in. They don't have any mechanism of if they need to sell at a later time, and they haven't got to their first time of figuring out how they're going to transfer those funds securely to the owner, making sure that they're not being susceptible to fraud.
Can I?
Yeah.
Yes, please.
Thank you. Can you dumb this down a little bit? Because virtual currency, I've heard people talk about it, but I need to know, like, how do we know it's unclaimed?
Okay.
What brings it to that level? And then once it's been identified as unclaimed,
okay,
what are you proposing the state do with it in this? And then how do they go about claiming it if they are able to claim it later on?
Yeah, perfect segue question to get to the rest of it. So virtual currency becoming unclaimed would only be existing with exchanges and some brokers, as we have a representative from Fidelity here as well, who's kind of getting into that game. So these are wallets that are housed through a third party. If you have a wallet of your own that you store in your computer that says, okay, I have X amount of Bitcoin, nobody could ever access that other than you. It's just the conundrum that the gentleman who has a computer lost somewhere in a landfill with billions of dollars worth of Bitcoin is never going to see that. And I think last I heard he gave up and trying to look for it. So these are just ones that would be funds that are held through a third party that can monitor these type of things. And so with what we're proposing is it would go based on no activity into the account. So you have an account at, say, Coinbase, which is the largest of the exchanges, and you may go into the account regularly and check your balances, or you may not go in regularly. What we're proposing is a 5-year dormancy as opposed to most other property that has a 3-year, to allow for the possibility that you're not going to go in regularly. Say with mostly it's going to be inactivity that's going to be the determined for if this is unclaimed property or not. So that means nobody's accessed the account. They've never actually had a transaction where they've took in securities or sold securities and taken them under. They've never deposited cash for potential future investments. Really just no activity at all. And then from there would be the responsibility of the business, so like Coinbase, to reach out to the owners and say, hey, there's been no activity on this account. Do we still have contact with you, or did we lose contact? I'll say I know Fidelity, and we've had discussions, would like to see some form of the return by post office standard, which is one of the big things back in May that Treasurer's Office said, we'll let that go back in. We're not going to try to remove that. It's a standard that the investment industry uses to determine if an account is truly dormant or not. So if the mail they send you is not returned by the post office, they consider it active, and so the account stays. If it gets returned by the post office, then they say, okay, we lost contact with them. Try any other way to contact them. If maybe they have a phone number, email on record that they can try to contact. If not, then in that situation, it's determined to be lost, and then start the process for due diligence and make sure. And usually, in that case, if the mail doesn't work, then due diligence isn't going to work. You're sent to the same address. The concern with using that strictly on virtual currency is these exchanges do not send out physical mailing. And so that's where I haven't adopted that within the proposed changes. But definitely a conversation that can be had maybe later. It just, I feel it's not going to work. One, it would be Coinbase would have to send out a mailing, and then if they came back, they'd have to record that it was returned by post office. And what our understanding from them, or through a third party with them, is that they don't have the mechanism to do such a thing. And so that's where I was kind of seeing that Maine, as such a small state overall in the country, is probably not the place to dictate that businesses need to start changing their business practice to start initiating mail and recording if it gets returned as a normal business practice. I think inactivity should be enough, and we give those couple extra years to ensure that determining if a person is lost or not from their account. I hope that kind of answers. I tried dumbing it.
We appreciate that very much. And I wanted to just sort of clarify so that when I'm going to have to explain this bill. So basically, what we're trying, the goal, if my recollection is correct with this unclaimed property, is adding, sort of recognizing virtual currency, adding definitions, adding what the process would look like, because more people are using it, more people have it. We need to have some defined way of determining what it is, when it's abandoned, what the process is going to be to consider it abandoned, and how that's addressed with. That's sort of the very bottom line, right? That's what we're trying to do with this goal. And I do appreciate the work that you guys put into.
As I said, I know that that's a big part of the changes that are there.
Yeah.
Then there's some other little pieces.
Sure.
Yeah.
Okay. Questions on this bill? You guys are abandoning me in my time of need. I can do this, I know, when I have to explain it. I'm looking at all of you.
If you want, I can kind of go over a couple other
Sure.
compromises that we've
Yeah.
made as well. So one of the things, and as early as yesterday, there was talk about the terminated retirement plan. So this would be a federally chartered plan under ERISA, so 401k type of retirement plan. When they decide that they're going to terminate that plan, that money needs to go somewhere if they can't locate the owners who invested into their retirement. And so states usually have a 3 to 5 year dormancy period on property, and that's too long for the sponsors for the plan to wait and determine what they need to do for sending the money. The U.S. Department of Labor wants them to close these accounts as soon as feasibly possible. So we did have originally in the language for a suggestion of when these accounts happen, they're to report as soon as administratively possible. It was brought to my attention yesterday that this was a vague statement, and what we decided to do is follow with what Illinois has adopted, which is that it's 1 year after a plan is terminated and they can't find an owner, that they turn it over to the state.
Can you,
Or they can potentially turn it over to the state as unclaimed property for the owner.
can you point me in the direction of the
Oh.
bill where I'm looking at?
Yeah, so
Page.
this ends up being section 4 and 5 of the. Yeah,
Okay,
so
I
it is
see
on
now.
page 1. So really the only change in section 5 is instead of saying as soon as administratively feasible, to say 1 year.
Okay, I see.
So that change actually is since the email last week.
Okay, so
um,
this document that was printed is the,
Is the
Officially
most
official.
recent. Yeah, there's very little change. There's only 2 little spots in here that are changed, but there is a change nonetheless. The next change I'll go, section 6 of the bill is in regards to retirement accounts. And so most of these changes were addressed in May with bringing back the return by post office standard. The one thing I did want to note, I think since May, was noticed that the title is when tax deferred or tax exempt is what I'm proposing. It originally said what tax deferred and tax advantaged. So tax advantage covers tax deferred and tax exempt. And so I think it more accurately says these 2 types versus this one type, and then the group, the title that covers both groups. And the difference being the tax deferred are things like your deferred comp and your traditional IRAs. Tax exempt would be a Roth IRA where you pay into that after taxes have been removed from you. And so you don't have to pay taxes when you withdraw once you retire. Okay.
What you just said just made me think, would it be advantageous for somebody to let their retirement go to unclaimed and then claim it through unclaimed property and have it be tax advantaged?
So the IRS had thought of that. If you have an account that becomes unclaimed, and the provisions that within the existing statute and what's proposed for the adjustments are still about the same. If your tax, if your tax deferred accounts are not used at the time that you turn of age by federal law, and to mandatorily take distributions, then it has a potential for becoming unclaimed property. And part of that protection is so that you're not continuously charged money out of your account because you forgot about it once you turn of age. Right now is 72, and can change. at any time that the IRS decides. And with that, when the count goes to unclaimed property, as reported, 10% is automatically deducted and sent to the IRS on behalf of that account. What we, yeah, and 5% goes to the state of Maine. So they make sure that they get their cut in these counts, so people can't use that method. What we do when there's claims for those properties is we let them know how much we were told was sent over to the IRS or Maine, basically we just give them the total of the pool. And it's, they can go to the company and get more detailed financials in case that their tax burden is less. Hopefully not more. But yeah, there are protections against that. And then when it comes to tax exempt properties, so your Roth IRA, there is no federal provision that says you have to take your money by a certain age or you're penalized. And so within that, the language that pretty much is if you've passed, then that would be the determination that this isn't a dormant account and gets turned over at that time.
Yes, Representative Copeland.
Thank you, Madam Chair. So this is a lot.
I know.
And I
know you had
appreciate
your
that you came
concerns.
back with my concerns from last time, and that was a long time ago, so help me with this, but so if somebody dies and they're gonna turn it over, what does that mean? Put it back into the pool? Or
So
why doesn't it go to beneficiaries?
well, it would. So the only time it would come to unclaimed property is when there's nobody that they can locate. First step when any account or check becomes dormant is that the holder reaches out to the owner. And there's no exact numbers, but it's believed to be about 40% is returned to the owner before it comes to unclaimed property. That's what's been found in audits that our third-party auditors have come across. So in this instance, if they determine that the owner is deceased, their first recourse would be to reach out to the beneficiary and try to get the funds to them. If they can't reach the beneficiary, then they've provided all avenues they can to reach the owner. That's when they say, okay, there's nothing that we can do to get this back to the individual or the beneficiary, that we're gonna have to report it to unclaimed property because we don't know
How
to
long
reach
does
them
it stay in, thank you.
Yep.
How long does it stay in unclaimed property? Like
in
if,
perpetuity or until claimed.
okay. That's why we have so much, okay. Just below. And I
Yeah, all
had,
right.
going back, I have a question about the the virtual currency. Do other states take it in? I mean, it sounds like there's maybe a couple, but why would we want to go through that process and spend a lot of staff time on that? Why can't we just say to somebody's going to give us some of that, make it liquid?
So that has been Treasury's stance of concerns of the industry. We've proposed this alternative to say that we are going to look at the best feasible option. And we can have both options available in statute.
Do
But
we have,
yes,
do we have to?
if we were taking virtual currency, there's the cost of having a custodian who will help manage that for us, because we wouldn't want to hold the wallet internally for the state and have the chances that we lose the secret code and then we lose
Right.
everybody's currency. And then
And
there,
people coming at it from different ways. I mean, it seems ripe for fraud. So why don't we just get it in good old US currency and
I don't disagree.
so what's the purpose of doing it so that it's convenient for them, that it's going to cost
So-
our taxpayers?
So some of the considerations around it, like in the state of Oregon, they were also in the frame of mind of let's just liquidate until they found through audits that they have an extensive amount, more for that state than any other state by population of virtual currency. I can't remember the reasoning that is believed, but
Does
for
that
some
apply
reason
to us?
they-
Do we have a lot of people coming and saying we're going to pay you with virtual? Who are these people that are gonna
Yeah.
pay?
Well, I think this is abandoned property, so there's no one trying to give us money. It's money that's just been abandoned. So there's not a person necessarily connected to it, right? So it's,
there is a person, so that there are
Which is-
owners' accounts.
okay.
What happens is, so Coinbase would say, you have an account, but they've tried to reach you and they can't contact you. You've had no activity on the account. We don't know if you're living
Right.
or not. And because it's reached its toll as a consumer protection that all states have, to try to protect the
Right.
individual's money, that they would report to the state as an abandoned account.
So there's
with
a
no other way
person,
to,
we just can't find them.
yeah.
Right, so it's not like, this isn't talking about like paying your bill virtual.
Right.
Okay, oh, I just wanted, okay.
No, for a moment.
So if, just like if we have a check, a bank has a check that we're trying to find, that somebody owns that check, we just can't find them. So that it goes through the process of to abandon, and this is
Right.
what we're going to do. So the rub, it sounds like what you just said is like Oregon looking at, all right, we have, I can't speak eloquently at all about cryptocurrency or anything, but we have X amount of dollars in cryptocurrency and we could just liquidate it, but potentially we don't want to do that because we might have, there might be
Yes.
more than we realize.
So there are concerns where, with Oregon, there's multiple $1 million of virtual currency that are potentially to be reported to the state of Oregon. From what we've seen from auditors that kind of just did a light touch on what would the industry potentially have, is under a couple million, maybe it had to end up being under $1 million after due diligence is processed. It's a very small pool overall. DC is the only one that's taking in the currency. They've been doing it for a little over a year now. New York has kind of kicked the can to 2027 before they start. And there's a few other states that are having a legislation addressed, mostly presented by Coinbase's lobbyists to also take in the currency in its native form. As I know, one of the concerns with that is the volatility of the market, and so somebody has their currency liquidated and then they come forward 5 years later, the value could be much more. And yeah, it could be less. Exactly. I've actually had many cases of that with securities where people say, what do you mean you sold my stock? And then when I looked, I said, well, we sold it when it was higher than what it is now. So, then they're happy.
Yeah.
Sometimes it goes the other way. We don't play the game. We have a straight policy on how we liquidate after we hold securities for 1 year, and whatever the market is, the market is. There is one party who expressed the idea of potentially paying the property in the form of, or in the value that it was at the time that a claim is created. That can become a financial burden on a smaller state. New York is one state that I know that does this, but they also have $20 billion in their unclaimed property pool. We have under 400 million. So there's a bit of a difference. And if you talk about virtual currency, in like Coinbase in early 2025, they went from 60,000 a coin to 120,000 a coin. And so you could be talking about money that the state never received that we have to pay out. And so I didn't bring that forward here. Not looking to do that, but I did let them know that that is a conversation that maybe can be had at a later time.
Did Representative Copeland, did you have any more questions? That was.
No, I just don't like the whole general dealing with the cryptocurrency. But my questions are answered. Thank you.
Okay. just kind of point out the changes. So section 8 speaks towards the presumption of abandonment. We added it where the provision was subject. So basically, because of the changes with virtual currency, we're saying that, oh, I'm sorry, section 8 was getting myself lost here. So 8, it was regarding minor accounts. And what we did to simplify the language is to basically say if it's a minor account and the owner is a minor, it's not considered for unclaimed property. We wait until they become of age. So minor accounts, that there's a minor who's the owner and there's a custodian who is like almost the power of attorney for that minor until a point that the minor is of age and can handle the account on their own. And so with that small addition is just to say, if it's a security account, it falls under the provisions of a security account on when it becomes abandoned. If it's a bank account, it falls under the bank account provisions and not defining when that gets turned over. Let's see. Section 10A also is in regards to the minors accounts, and just saying that property are no longer subject to the minor UGMA minor account provisions. It's going to fall to the property type once they're of age. 10B is on stored value card, and I think I kind of introduced this at the tail end of the last work session as different parties within the retail industry about reporting stored value obligations. So this could be, you put money on your app for Roma Joe's or what was that? Oh, yes. Yeah, so different than a gift obligation, which is a card that you would hand over, but you have an account that's registered in your name and you have funds in that account. The way that the statute is currently written, businesses have to report that property type on May 1st, while all other property types are reported on November 1st. So they have to report to our office twice a year. So this is just a small change to bring the stored value reporting to November 1st, along with all other property types, so that businesses only have to report once a year to the state. It was a May 1st, and it made sense to be there before when gift obligations were reported to the state of Maine, but that is no longer the case.
So on 10B, on this that I'm looking at, it says June 30th. Am I looking at the wrong section?
Nope, you're not. May reporting is based on a calendar year of January 1st to December 31st, and then it gets reported on May 1st. All other property goes on a July 1st to June 30th report year and is due to our office by November 1st. So similar to taxes, the year ends in December 31st, but is due in April. The reporting, you need to give time for businesses to reach out to the owners, try to get that money back to them, and then when they can't, put together a report of what's being sent to the state as abandoned. Okay, yeah, I think that could be. So the June 30th is the end of the reporting year.
Okay.
And so that's standard for all of the property types.
Huh.
That just seems like we should clarify that.
Okay.
I just want to be sure, because it just didn't match what you were saying before about this. Is this related? This is still the stored value card?
Yes.
The property account. So June is amended, maybe because we're not reading the rest of the second, amended to read June 30th of the year in which the obligation is issued or additional funds are deposited into. Is that the correct date that you're looking
So
for?
that's
Okay.
the report date, and the
Okay.
report is due in November.
Okay. Yes.
Yeah, if I may, is there more in that statute that maybe that isn't present? I'm sorry, I don't have that statute, but I'm just wondering if the question I heard was whether or not, it sounds like there may be a
I
report.
think there is.
So a report's
more-
due in November, but the information for that report, is that due June 30th? Is that what that?
Yeah, because this is provision A and there's going to be a part that's separate from that. If I recall right, B would say that insurance policies would have the November 31st insurance
Okay.
companies report policy funds to pretty much all states in the spring. So that one would stay the spring as it works for them.
Okay.
But all of the properties we're looking to have reported to us in the fall or due to us in the fall.
I just wanted to make sure it matched up what you were intending. I didn't
Yes.
want us to make the changes, you know, if it didn't.
And yeah,
Kristen-
we're looking up the full portion of that.
Yeah, I forgot that actually might be in the salmon here. I'll see if I can find the page. The title 33, it looks like section 2066. Let's see. Okay, I think that section of law as presently written is on page 11 in the salmon packet, 2066, subsection 1A. And that may help. I don't know if that will help with the current discussion around the November reporting or.
Okay. So you're changing it from December 31st to June 30th.
Which will change the
Okay.
date.
And,
Yeah.
okay,
Of when we receive it. So all other property types, accounts receivable, accounts payable, payroll, they're all due June 30th as well.
okay. I trust you. Thank you.
Or
Okay,
I would say the reporting period ends June 30th.
okay. All right,
So we have 2067A in section 11 that has a big portion of the red changes, and this is to incorporate the possibility of receiving virtual currency in its native form when we find that it's reasonably possible.
okay,
And lays out the practices, including when to remit, how to remit, providing the ability for the treasurer to say, we don't want to take that if it's something that is worthless. There's a lot of worthless coins out there after the last couple of years. People make coins to make money and
No.
everybody else loses.
1969.
And so just trying to address all the possibilities that happen. And then the provision of
This is
holding the state and holders harmless in the course of the liquidation of the currency. Section 12, we're suggesting to not amend. So, and this is to bring back in the return by post office standard,
Okay.
another section. I'm gonna go to, and then in 15. This is in regarding to retained asset accounts. So if you have a insurance policy with the company and pass away, the money goes to beneficiaries. Retained asset accounts are like bank accounts the insurance company sets up to hold those funds. And so what we're just looking to do is add the clarification that those become reportable after 3 years of inactivity or not being able to contact the owner. Similar to a bank account was currently.
Okay.
16A.
Oh,
Yes, Representative Cooper.
thank you, Madam Chair. Well, we're talking about the interest in the account, the person's last interest in the account. But
Yeah.
then I read in here somewhere that virtual interest, like if you're going online and looking at your Fidelity account or whatever, And that doesn't count as interest.
Right. So that would be something that's not initiated by the owner, so not an indication that the owner is aware of the account.
Well, no, but if somebody goes on there and, certainly they monitor every
Yes.
keystroke, they know that you're on there. How can we say that that's not interest?
So that would be interest logging into the account, but the
Okay.
applying of interest, so say your savings account at the bank, you automatically have a certain amount of money that's applied to the account. That's not something that the owner initiated.
Okay.
So there's no real indication that the owner is aware of that account. You could be, the owner can be deceased and
Okay.
then that would still happen.
Okay. Thank you.
Yeah. Yeah, interest kind of has two different meanings when it comes to unclaimed property world. And so 16A is also the change for having to do with stored value obligations. And it strikes out stored value and gift obligations from the requirements of reports that must be filed by May 1st. And I think this is where it kind of gets into some of the pieces that weren't there because it's in 3 different sections. Let's see, section 18, that's also a virtual currency.
Representative Copeland?
Thank you, Madam Chair. So before we move on, stored value obligations.
Yeah.
Can you define that?
So it would be an electronically stored device where there's value and it generally is registered to an owner. So I kind of mentioned the Aroma Joe's app when you can store money on there. That would be a case of it. Oh, yeah. Okay. Apple Card would be another one. Anywhere that you store money and you are the registered owner, as opposed to an application where you have money stored and anybody could use it. It's a bearer instrument.
Thank you for that clarification.
Let's see. Section 18 just has a small part around virtual currency, allowing for the ability to sell currency, and this would be primarily if we were to receive in the currency in its native form. The general provision would be we'd treat it similar to other securities and sell after holding it for 1 year. I'll say that the office goes to great lengths to try and make sure we notify owners before any security is sold. We send direct mailing out to them every year, and then they're also added to the list that you all receive, and reaching out to constituents. We make sure at the minimum, there's at least a direct mailing going to them to let them know that there's a property held with our office. We would like to get it back to them, and that there's a potential of a liquidation. So that's why we wanted to get it to them quickly. And we do get a lot of good responses from them. Let's see, 19 has a provision that's also, I believe, that's just an added piece regarding virtual currency. Section 23 is striking out the stored value obligations. And yes, you got to read what's before it. So it's a holder that in May 1st for insurance property, and it's striking out stored value, and November 1st for all other. That's the third piece to that covers, I think, those concerns. Section 23A is also just adding pieces for the virtual currency changes. I said there's 9 sections within the statute that need to be addressed for the virtual currency. 23B is also for virtual currency, and it's all related on how we manage them, and the selling and the protections, or the receiving in its native form. 27A think where we actually get into a different discussion. Just trying to go back to my notes here. So these are around audit changes. We're trying to further protect the data when we use our auditors or third-party auditors basically to audit companies. And there's a lot of pushback when it comes to auditing, and our director stepped out, but she sees a lot of it within the discussions because the companies will come up with anything they possibly can to delay an audit or avoid it altogether. And with that, we have hundreds of audits that are still pending because of delays. And we're trying to put a little more teeth within the state statute to help with that, and hopefully not rely so much on NDAs when there's already federal, already state protections of that data. And that's actually the last change from that we have from the last session. I'm happy to speak towards any of those items. I'm just trying to look, you know, the big part of collaborating with others was the return by post office, that as a collaborative approach. And oh, there was one other place that did have a change. This was in section 7 from when I emailed out on Friday, and this also came from Pierce Atwood. Yeah, okay. Sorry. And that is in section 6, it's on page 2, is for part V, it's in reference to the United States Internal Revenue Code. For some reason, Maine had adopted of 1986. I don't have a strong opinion one way or the other, but what was pointed out to me is that no other state who has adopted this provision of the RUPA language included the year of the internal tax code. But I did kind of put that in there as something that was brought up. It's really just to strike out 2 words. Doesn't change anything. Still kind of has the same meaning, I suppose. If the federal government was to repeal the entire tax code and start a new one, that could make a difference.
Representative Greenwood.
Thank you, Madam Chair. So there's a lot to digest here.
I know.
And I know this was a carryover bill, and I know it apparently has been worked on with outside parties since. What is the magnitude of significance of actually enacting this? What would be the implications if we didn't enact this? Can you talk about both sides, please?
Yes, I can talk about, so some of the bigger pieces of not enacting, virtual currency is a big topic, and it continues. It's not going away. We did avoid it in 2019. It is addressing it within the statute, but things just expanded from there. If we don't adopt anything that we think right now, my understanding is that there will be lobbyists here next session to propose whatever they think it should be for virtual currency. So that's something to look forward to. The other large piece that the Treasurer's Office has concern with is kind of at the end, and I didn't touch on that one yet, and it has to do with the confidentiality of records. Oh, yes. So this would be section 28 and 29. Mostly 28, I think, is just to add to be able to add to the existing provisions. Let's see. 28. So No, it already existed, so, but it's really just to add to the title for definitions, applicability, confidentiality, and use of documents and work papers. And then 29 is, this is language that was in our law before the repeal and replace in 29 for the RUPA language. What we found out after that happened is that it opened the data that we hold for owners to potentially be FOIable, including all their PII. So we would like to reintroduce that piece of the language so that we can protect that data from only being available to vetted entities. So what exists is the vetted entities, obviously our office in advertising through any outreach, and we have the website, which is a much more manageable, searchable database as opposed to data mining the entire database and then using it to your will. As far as in a bulk, we provide a list to the legislature for their constituents only. So only your district. And we provide at times to town clerks to advertise a list within their office, not for promotional distribution, just to try to keep, and we don't present that in an electronic form for them to then sort and manipulate to their ability. And then there are finders who are private investigators who look to find owners for a fee. And they have those protections to be able to do that through the private investigator laws. But trying to limit from a general public or outside entity who it has been a problem in the past could receive a state's database and then create their own database and start charging people to find out if they have unclaimed property. And usually that's like a monthly fee for $30 a month. And you can't get them to stop charging you until you cancel your card. So that has been a problem in the past. And so we want to protect against that by bringing in the existing language that we had before. So those are important ones. I'd say some of them are very simplistic. The changes around direct deposit accounts, CDs and bank accounts, that's just kind of a clerical correction because it's all lumped into one place and becomes conflicting in the way that it's worded because it makes it sound like bank accounts have maturity dates that CDs have. And so we're just trying to make that change as just a clarification. Retirement plans, if we don't adopt that, that would mean as it is currently, nobody can wait 3 years of dormancy to turn over a terminated retirement plan. So they generally get turned over into a Roth IRA, which becomes feed until the balance is depleted. And the owner has no knowledge because the reason why they turn it over is because they can't locate the owner. So it just becomes an account that sits out there until the fees eat it all. With the treasurer's office, we can at least advertise the name and try to get that money back to them, and we don't charge fees against it. The tax benefit accounts, the uniform gift and minor accounts, and other security accounts, those changes are simply just to make the language less cumbersome. So there's no real impact whether you adopt or don't adopt, other than the fact that it, how it reads for those trying to interpret the law. The one piece in the tax benefit that would make a change, we currently have 70.5 years as the age to turn over accounts, because that's what was in the original RUPA language and was the federal tax code. At the same time that we've adopted the RUPA language, the federal government that changed the age to 72. So we're out of out of sync with the federal government. That's probably the big piece there. Stored value obligations, not adopting, again, that's just requiring businesses to file with our office twice a year as opposed to just doing it once. Automatic withdrawals, I don't think there's a big consequence there. There are concerns brought up about electronic activity, whether it gets considered activity or not. And we talked a little bit about the automated transactions and how automated transactions are not an activity of the individual. So we don't think it should be counted as activity to keep an account active. There are some different opinions on that, and I didn't provide any changes within this package at this time. I think that probably would need more discussion externally of if we are to make the changes, the changes that are there, I'm actually open to go either way, whether we change it or not on those section 13. If that became like a sticking point, is really, we feel that no non-activity, say you set up Netflix to debit your account every month, that's generally not going to be the only thing that's in your bank account. But if it was, after 10 years, that's still going to be the only activity that happens, and you have no active participation in that, only in the first initiation of it. And so that's not, I feel it's not a good gauge to determine if this is an active account or not. But generally, if you have a bank account, then you probably also have other deposits, or you may withdraw money at some point in a 3-year period for cash, or any other transaction, write a check, that type of thing. I know some of the concern gets involved with financial companies. So you have a stock portfolio and there's dividends that are automatically deposited into your bank account. The concern is, as long as that, or the idea is that as long as that money is successfully deposited into the account, it's considered active, which may or may not be the case. Both can keep themselves, both that one transaction could keep both the stock account and the bank account considered active in that respect. And I had provided the examples of individuals having that issue long after they've passed.
We have something up on our monitor.
I can calculate.
Retained asset accounts, that's just more of a clarification. It probably wouldn't affect too much. Determining authorized state, that's section 16, and it's really just specifying that when an owner is deceased, property goes to the state of a beneficiary that's listed, if there is one. And then if there's no address known for the beneficiary, it just goes to the state of the original owner. A very small piece, but just a kind of a clarification. We do have about sheet fees, and I leave that up to the committee to decide if their opinion on that. It essentially isn't a form of junk fee, where businesses will report property to us under their requirements by law, but they'll charge the owners up to, I've seen up to $126 for a money order that gets turned over to us. They just put that money for themselves, and then they send the balance to our office.
Anyone else that wanted to
Yeah, I mean, as far as really important stuff, oh, I can talk about unclaimed property all day if you want, but I don't think there's really anything. Oh, one other piece that's really important is section 22, the duty to report. So this comes out of a circuit court case in Minnesota, no, Michigan, sorry. I always get my M's, even though we are one. So the court was asked to consider whether the commencement of an examination, so saying that you're looking to examine a company, tolls the statute of limitations for enforcement. The way that RUPA was drafted, which is what our law is based off of, they said, no, it doesn't. And so essentially a business that is under audit could then say, okay, well, I'll get back to you, and they can hold you off for, say, the 10-year allowance for the look back period of the company's records, and then say, well, 10 years is up, you can't audit me, that stuff is more than 10 years old now. So just this addition of the language will then set that the announcement that we are looking to audit sets basically the commencement date so that whether you hold them off for a year or 5 years, you're still obliged to be audited for that time period. I'll try to hold back. I know it's a lot.
Okay, no, that's all right. Thank you so much for that, and I appreciate the work that you put into this bill. I know it, for us, it's very complicated, and I'm sure that I appreciate you taking the time to go through that. Does anybody have any questions? Oh, yes, Representative Tool.
Thank you, Madam Chair. I guess my main question, when we left last session, was there seemed to be a lot of disagreement between the various stakeholders and some controversy, and we all felt like we really needed 6 months off to reboot and see if folks could get on the same page. And I guess my main question at this point is, and it sounds like it is, are folks on the same page with what we have presented here now?
I know there's two
Yeah.
individuals here.
Yeah.
Happy to have them speak.
Sure.
But I feel that we've talked to all parties who have reached out to us.
Okay.
And aside from 2 spots that I wasn't comfortable with, we have made compromises.
Okay, awesome. I think some of the stakeholders are here today. If anybody wanted to speak, that would be great.
Joe. Watch that chair.
Hi there, welcome. If you could just introduce yourself.
Sure. It's told to be careful sitting down. Madam Chair and committee, there we go. Committee members, it's a pleasure to be back. My name is Joe Murray, and I work at Fidelity Investments. I work and live not far away in New Hampshire, where we have a campus. We also, for the state of Maine, we have about 60 employees who live and work in this state, and approximately 100,000 customers who use Fidelity for various different financial services. So I'm happy to go into just some targeted, focused points that I can share, with really the main point being how much we appreciate working with the committee and with Jeff and the treasurer's office on this bill. Really great progress. Most importantly, we appreciate the amended version, how it reverts for securities accounts to return mail, or the so-called RPO standard. That was our core concern back in May, and we're very happy that that this was accomplished. And we hope that that the bill retains this approach. Jeff mentioned a lot of the changes in this bill relate to digital assets. The language we think is much improved overall in that regard. There are a couple of areas where we would hope to get some clarification. Specifically, and we know it's a complicated assets, we don't even know what to call them, digital assets, virtual currency, both. But it has to do with how our customers, and we look at things from our customer viewpoint, how they communicate with us and how we communicate with them. And so while, as Jeff mentioned, communicating by mail to customers may not be the preferred method for companies that are purely crypto firms. We have customers across the spectrum. They very often, and most of the time, hold securities accounts, brokerage accounts. They might have a college savings plan with us, and they may also hold crypto as well. We communicate by mail to all of them. And from that customer perspective, we think that we're always trying to make that experience consistent and predictable for them. So we think having that mail standard count for crypto customers as well as all of our other customers makes sense. So we actually had a sidebar and I think made some progress talking about how we could make that happen. So we hope to keep talking about that as well. We've also really, what we're trying to avoid on behalf of our customers is premature or unnecessary escheatment. And we've done a ton of work over the past year plus on this, both internally and with our constituents in terms of trying to educate them. If it's hard for you all to understand this issue, you can imagine what it's like for customers. So we've done a lot of customer education on this issue and think we've made some progress there. Still, we just need to make sure that these bills, and this, we think by and large is a very good bill. With a couple of more tweaks, it would be even better. So I'm happy to answer any additional questions on that. There are a couple of other issues we've been talking with the office about as well, but relatively minor.
So just to confirm that the bill as it is right now, if we move forward with this bill, you feel like that's good progress but any other changes or something that you would still be in conversation with the department about, or we're sort of running up against the deadline of getting the bill passed.
Right.
Are the changes, and it sounds like from what Jeff just said, perhaps not changes that they're willing to make at this time? I don't mean to put you on the spot, Jeff, but you know what I mean? I'm just trying to get a feel for where we're at, like with the bill as it stands right now.
Yeah, I think to put it straightforward, if there was a way to ensure that customers for a firm like Fidelity, which has customers across the spectrum, we're looking at having a pure account inactivity dormancy standard is a problem. We think, and that for these customers, at least the customers who have multiple accounts with Fidelity, who are already currently receiving a consistent communication by mail, that should be the standard for at least those customers.
Okay.
Did I put that accurately? Is that kind of what we're looking at? There's a better way to do it. We're open to it.
Okay.
Yeah, and I don't even think that we would argue if you were doing mail that and it was, and you see under the RPO that it's an active account, even though it doesn't specifically have it for. And the reason why we didn't for virtual currency is because those exchanges don't do that. But what Joe and I had kind of discussed was if you have an account and you have securities and you have virtual currency in there, then because the securities in there, you're covered by the return by post office provision. And by association, the virtual currency that's in there would also not be reportable.
Okay. That gives us great comfort to hear that.
Okay. So good.
Something
Is that something, I mean, it just seems like a simple line. Is it something we could add into what's before us now to satisfy both sides?
I think so. If we could do that, we're happy to work on that. If it's something that we can put in writing that makes that clear, terrific.
Like if the holder produces.
Yeah, do you want to?
Oh, yeah.
Sure. Come on up.
Just thinking something like if the holder on a regular basis produces mail, then the return by post office provision would apply to this property. That sounds good to me.
Did you get that, Chris?
I got it.
Okay. Oh. it's not it.
Would apply. Yes, and I can always go back and confirm, and depending on how the committee proceeds, certain permissions can be granted to me to clarify if needed.
Okay. Is there anything else that you wanted to add? Any other concerns?
No,
Mr. Murray?
that's, I mean, that's exciting action and live.
We love that
so
real action. We aim to please.
That's amazing. Sure. I mean, obviously we'll take that back and review
Sure.
it. Hearing it once is never enough, but we'll be in touch.
Okay, great. Thank you.
Pick that up on language review if there's an issue.
Right.
Sure.
Yeah, definitely. Yes, sorry, Representative Barron.
Thank you. How long has Fidelity been holding cryptocurrency? Is this something fairly
It's a growing
few
business.
months, or has it been quite a
Oh,
couple of
it's
years?
been several years. It's a
Okay.
growing business for Fidelity. We've been researching it as.
So you've
as
been
usual.
involved for quite a while.
We have.
Okay.
Yep.
Great, thank you. Other questions? Okay, thank you. Is there anybody else that wanted to speak on this bill? We're all set, thank you.
Thank you.
Hi there, welcome. Hi there, if you would just introduce yourself, that would be great, thank you.
Thank you, Chair Salisbury, members of the committee. My name is Ann Robinson. I'm a lawyer with Pierce Atwood, and I'm here today on behalf of the American Council of Life Insurers, which are the trade association of the country's leading companies that provide financial security to people throughout Maine and throughout the country. I wasn't really planning to speak per se, but I did want to answer I guess the basic question that was asked about how the stakeholders feel about this. And so let me just say that our focus, my client's focus, was really limited to a couple of sections of the bill. So first and foremost, we didn't have any part with the virtual currency, so I can't speak to that at all. But as the state treasurer's office, as Jeff indicated, we did have concerns about the vague term that had been used in the provision dealing with terminated retirement accounts about administratively feasible. And we think the 1-year provision is clearer and is kind of consistent with, for that matter, how the IRS looks at that issue. So, and then we agree that we had the same concern about the in the tax deferred and tax exempt provision, that the age that was specified in the existing statute is now outdated. So we agree that needs to be updated. So really that was what we were concerned with, and the proposal that you have before you, from our perspective, addresses those concerns. And we really appreciate the time that the treasurer's office took to work with us on this and your time. So thank you.
Great, thank you. Does anybody have any questions for Ann? Wonderful, thank you for your time.
Thank you.
Okay, anybody have any other questions about this particular bill? Okay, great. Let's see, is that our last bill? No.
We have one more.
We have one more, LD 1577.
That's great.
This is the resolve to establish a commission to study and recommend solutions for modernizing the Maine legislature. We'll just take a few minutes to switch. Switch.
Oh,
1577, thank you.
So where are we on 1570?
Excuse me. Thank you.
Before we begin now.
Say it again?
Before.
Huh?
You make motion, I'll second it, and then
Moving on. So this bill, again, I read you the title. This is a bill that was sponsored by Representative, Riley. I have spoken to Representative Riley, this morning. I confirmed the request from the sponsor is ought not to pass on this bill. There is another bill that's a similar bill that is on the study table that was, submitted by Senator Stewart. So again, I did confirm this morning with Representative Riley, he is requesting ought not to pass. I would like to make a motion ought not to pass.
Thank you, Madam Chair. Hearing from Representative Riley, wanting ought not to pass, I will second that.
I'll just wait for Liv to catch up with us. No need to be sorry. We're zipping right along. While we're waiting for, Liz, does anybody have any discussion or questions? Representative Tool? Oh, yes.
Thank you, Madam Chair. And the bill aside, as a side note, I had a initiative this past session to make the legislature bring it more into the 21st century as far as the public goes and make it more transparent and accessible through things like YouTube and that. And I'm very pleased that both the speaker and the legislative council have made some strides and that we are now on YouTube and Roku devices by extension. And I think there is progress it's being made internally. So while this bill may be going down, I think there are some accessibility things that are being addressed. And there's a long way to go, but I think we're modernizing.
Thank you for acknowledging that, Representative Tool. I agree with you. Anyone else? Okay, Liv.
We'll begin on this side. Representative Farin.
So it's
I'm
ought
sorry.
not to pass.
Yes. Sorry.
Yes.
So, just to reiterate, ought not to pass on LD 1577. Sorry about that. Thank you. And Representative Farin votes yes. Representative Rollins.
Yay.
Yay. Representative Rollins votes yay. Representative Copeland.
Yay.
Representative Copeland, yay. Senator Beebe Center.
Yes.
Senator Beebe Center, yes. Senator Martin, absent. Senator Baldacci, absent. Representative Salisbury.
Yes.
Representative Salisbury, yes. Representative Gramlich.
Yes.
Representative Gramlich, yes. Representative Greenwood.
Yes.
Representative Greenwood, yes. Representative Pomelo.
Yes.
Representative Pomelo, yes. Representative Adams, absent. Representative Underwood, absent. Representative Tool.
Yes.
Representative Tool, yes. With 9 members present, ought not to pass, unanimous.
Great, thank you. And just to confirm, Representative Greenwood, you wanted to have an opportunity for your caucus to meet,
Yep.
and then we'll come back to vote on the remaining bills. So how long do you think you'll need?
5 minutes.
Oh, well, there you
Yeah,
go.
something like
Let's
that.
give it 10 because I need to run it off. All right, we'll be back in 10.
All right, welcome back, everybody. Thank you for your patience. And we're just going to go back through the bills that we haven't voted on yet so we can wrap things up for the day. Thank you all. The first is that we'll go to is LD 849, which is a bill and act to establish a recall process for public school board members. What are the wishes of the committees? The committee. Okay, I'd like to make a motion, ought to pass as amended, and the amendment will be the wording that we spoke about earlier about making a carve out for communities that already have a charter in place that deals with the recall of school board members.
Thank you.
Yes, please.
I can wait if you want, just a point of clarification, or if you want to proceed however you'd want to.
Is there a second? Yes.
Second.
Second, Representative Copeland. May I ask a point of
Yes, question.
Thank you, Madam Chair. I was just wondering if that was an amendment to the bill as printed, or using a version that the sponsor distributed today as printed with the distributed amendment, but including an additional amendment whereby it's the carve out for communities who already have a charter.
Yes, so
Letter.
this
Thank you.
wording would be added to the amendment that was presented today.
But not just have a charter that addresses the school board recall process.
Perfect. Point of clarification. So that was that have a charter that addresses, was it specifically the recall of school board members? Was I correct in that? Okay, thank you. School board members.
Okay, so we have a motion and a second. Any further discussion? Yes, Kristen.
I just had one point of clarification, a technical consideration I had noted. I know the sponsor did provide some clarity, but sometimes when in statute, when we use the term voting body, which does appear in the sponsor's proposed amendment for today, sometimes that is often interpreted as like a governing body. And it is my understanding the way the sponsor described it today is the voting body that language intended to reflect was the electorate or the group of persons. Do I have the committee's permission to make technical changes if that is to be moved forward with, such as clarifying or using some technical language to make that revision to align with kind of statutory language construction if the committee were to proceed with that?
Yes, does anybody have any objections to that? So that would be fine. Yes, please.
Thank
Go
you.
ahead.
The second piece is I noticed there's some cross references that had been removed. And again, I don't know if the committee feels comfortable with providing with me the latitude to either clarify with the sponsor as a technical revision if there was a reason why those cross references were removed and other technical revisions, or I could say broadly speaking, if the committee felt comfortable giving me permission to speak with the sponsor regarding technical concerns I have for drafting.
No, I'm fine with that. Does anybody have any objections to giving Kristen the latitude to meet with? Yes, Representative Copeland?
I have no problem with giving Kristen the latitude to discuss it, but can we just see it on language review?
Absolutely.
Thank you,
Okay.
Madam Chair. That concludes the two concerns I wanted to raise for the committee's consideration. Thank you.
Okay, great. Any other discussion or questions about LD 849? Okay, go ahead, Liv.
So in regards to LD 849, the motion ought to pass as amended. We'll again begin with Representative Farren. I'm sorry. So, sorry. LD 849, the motion on the floor is ought to pass as amended.
Yes.
Representative Farren, yes. Representative Rollins.
Yay.
Representative Rollins, yay. Representative Copeland.
Yes.
Representative Copeland, yes. Senator Beebe Center.
Yes.
Senator Beebe Center, yes. Senator Martin, absent. Senator Baldacci, absent. Representative Salisbury.
Yes.
Representative Salisbury, yes. Representative Gramlich.
Yes.
Representative Gramlich, yes. Representative Greenwood.
No.
Representative Greenwood, no. Representative Pomelo.
Yes.
Representative Pomelo, no. Excuse me, yes. Sorry. Representative Adams absent, Representative Underwood absent, Representative Tool,
No.
Representative Tool, no. So 7 members voting ought to pass as amended with 2 members voting no.
And I would just add that my minority report would be ought to pass as amended, keeping in the spirit of the bill. It would be to the effect of something that we used 2 years ago on a similar bill, excluding towns that have a charter that have a recall provision, or ordinance towns that have a recall provision that would allow for recall by citizens petition of 25%, keeping in the spirit of the bill. However, adding that they also may and I'll share this with you, Kristen, but it's adding the following in section 2506, subsection 2, the following: a general statement of the reason why why the recall is sought. And I'll share this with you.
Okay, great. And we'll give you permission to work with him to create that minority report. Do you have any questions?
Yes,
go
just a
ahead.
point of clarification, Representative Greenwood, is that using the version of the amendment distributed today as the basis with those 2 articulated changes?
The bulk of the language is coming from what we worked on 2 years ago from LD 1102.
Oh, thank you. Okay.
Which was in our packets today that we received for previous work.
Thank you. I understand. Thank you for that point of clarification, using LD 1102 with those changes. Thank you also for the permission to work with you on that report.
All right. Yes. Yes, Representative Tool.
I'm also with him on that for a point of clarity.
Okay, thank you.
Thank you for that. Okay, and just a reminder, LD 1577, we did have a unanimous ought not to pass. LD 1741, we did table earlier today. The next bill is LD 1744, which is an act to modify provisions of the state civil service system governing employee recruitment and retention. Representative Rob.
Madam Chair, I move to table this. Do I need a date specific? No, okay. Motion to table.
Representative Bramlett has seconded that. Representative Bramlett has seconded that. Second, Mike. Okay. Yes. All those in favor? This is unanimous. Thank you. Give you a second there, Liv. Okay, the final bill is LD 1969, which is an act to amend the Maine Revised Unclaimed Property Act. What are the wishes of the committee? Representative Greenwood.
Thank you, Madam Chair. I'll make a motion of ought to pass as amended. And with the amended, I mean the version that was handed out today from the Treasurer's Office, with the additional amendment that was read into the record about the mail standard
From the Fidelity guy.
from the Fidelity guy.
And we do give you permission to work with the sponsor and any stakeholder to clarify that additional wording.
Thank you.
Yes.
If I may, the office, if it's okay to work with the Office of the Treasurer, as well as, and you mentioned any stakeholder that provided language today.
Yes. I'll second. Okay, seconded by Representative Gramlich. Any discussion? Okay, Liv.
So, excuse me. In reference to LD 1969, the motion ought to pass as amended. Representative Farren. Excuse me, Farren.
Yes.
Representative Farren, yes. Representative Rollins.
Yay.
Representative Rollins, yay. Representative Copeland.
Yes.
Representative Copeland, yes. Senator BB Center.
Yes.
Senator BB Center, yes. Senator Martin, absent. Senator Baldacci, absent. Representative Salisbury.
Yes.
Representative Salisbury, yes. Representative Gramlich.
Yes.
Representative Gramlich, yes. Representative
Greenwood.
Pomelo, or excuse me, Greenwood,
Greenwood, yes.
yes. Representative Greenwood, yes. Representative Pomelo.
Yes.
Representative Pomelo, yes. Representative Adams, absent. Representative Underwood, absent. Representative Tool.
Yes.
Representative Tool, yes. With 9 members present, unanimous, ought to pass as amended.
Right, fantastic. That is our work for today, unless Kristen had something that she wanted to pass along.
Nothing more, which I'm sure the committee may be glad to
Thank
hear
you.
for today.
All right, thank you, everybody. We'll see you all next week and we are adjourned.